If I don't do nothing else, I'm gonna talk that law. Let's talk about it. For those who may not know me, I am a Texas trial attorney, going on my 5th year in the game. Y'all see the law license on the wall signed by the 9 justices of the Supreme Court? Now, I was minding my business. I was drinking my water. And I got an email saying that the YSL trial judge is officially accused of collusion with the prosecution. I just got off of live. I was on live for like 6 hours. And I think I was off for like 15 minutes and I got the notification. And some said, get back on. Get back on real quick. So I said, let me get on. It ain't gonna hurt. I know y'all busy, y'all at work. Y'all can watch it later. But we gonna go through the motion. So when y'all do watch it later, y'all can see. I already said the judge was corrupt. But now we got it in black and white. We got it on paper. They say put it on paper what the judge did wrong. Bastard. Because he shouldn't have did it. And Brian Steele, before my live stream ended, someone had asked me, they said, what do you think Attorney Steele handed to the judge? And I said it was probably a motion to recuse the judge. And sure enough, as my name is TalkThatLaw, that's exactly what the hell it was. I said, I know you lying. He put it in the judge's hand. He already e-filed it because we have to e-file stuff electronically. But now, oh, hey, 313. No, I just want to give a quick update. So Brian Steele officially filed a motion to recuse the judge, and he accused the judge of a lot of salacious allegations. So I just wanted to do a video so people can watch later on, when they get off of work. And I was going to go through the motion a little bit. Someone sent it to me. I think her name was Tia. Thank you so much for sending that video to me whenever you see this. Not video, motion to me. We got the paperwork. They sent the paperwork. So I just want to just go through a little bit of it. And I'm so wore out with reading and I'm tired, so I'm going to skim read it unless somebody else want to read it. But let me go through. Let me see if I can pull it up. Let me see if I can pull it up. This is wild. Judge, what are you going to do? Are you just going to... Can y'all see that? Y'all need to make it a little bigger. This was filed today. Let me see if I can get a better layout. Oh, that ain't gonna work. All right, maybe this one. Maybe I'll make it bigger. Oh, it's good. All right, thank you. Okay, thanks. Let me slide that over there. And this was filed today at 4:59. Golly, so that must have been right after we got off. They filed it. State of Georgia versus Jeffrey Williams. And Judge Glanville, motion to disqualify, recuse the judge, Glanville, from all further dealings in the above referenced case, and motion for a mistrial, which was goaded. Not goaded, Brian. Goaded by the improper conduct committed in concert by the court and the prosecution. Golly, Brian. Brian ain't playing. And that's why he wanted to see when you dealing with your enemies, the ones that don't mean you no good. Sometimes you gotta let them know, yeah, it was me. I'm not gonna electronically file it. I'm gonna put a paper copy in your hand so I know you got it. Yeah, that's why he was quiet. He was plied. He was plied. He was plotting. Brian said, I'm finna get you after this court hearing. Let's keep reading. Comes now Jeffrey Williams through his attorney, Brian Steele. And this is a motion to disqualify and recuse the judge from all further dealings and a motion for a mistrial. And in support of this motion, Brian Steele, Jeffrey Williams will show as follows. Brian Steele represents Jeffrey Williams, Young Thug. The jury trial of multiple accused persons commenced on January 4th, 2023, before the Fulton County Superior Court Judge Glanville with his no good ass. Excuse my language, but he did it to himself. The trial is expected to last at least through the end of the 2024 calendar year. Brian, at the rate they going, it's going to last longer than that if you want to play all these videos. So on Monday, June 10th, within 5 days of the filing of this timely motion, this court, along with the prosecutors, engaged in unlawful, improper, ex parte meeting with, among other persons, a sworn witness, Little Woody, for whom an order of use immunity had been issued on Friday, June the 7th. No notice of this secret ex parte meeting was provided to any attorney for any of the criminally accused in the case. In fact, the accused and their counsel were in the dark. In the dark, like the judge was in the dark, making backroom deals. In the dark that this Star Chamber meeting had occurred. Not the Star Chamber, come on. In the dark under the stars. Under the cover of night. Woody had previously been called to testify on Friday, June 7th. He asserted his Fifth Amendment privilege in open court in front of the jury. And he was held in contempt. Little Woody was held in contempt. And he was arrested and put in jail until such time he agreed to testify pursuant to the grant of use immunity. And be very clear, when they're using that word use immunity instead of just immunity, it's only his testimony that's covered. Judge Glanville and the prosecutors essentially admitted by silence and by statements in open court that a secret meeting had occurred on the morning of June 10th, 2024, only after Brian Steele revealed his information that the meeting had occurred. So they only told once they was called. They didn't come to the front and say, we had a meeting. Once they were called, then the judge said, oh, all of a sudden, yeah, we had a meeting. Is this real? No, I typed it up myself. Of course it's real. It's hot off the press. Let's keep going. This is wild. At the earliest opportunity on the afternoon of June 10th, 2024, the court was informed based on information and belief that the secret meeting with the sworn witness Kenneth Copeland, aka Little Woody, and the prosecution occurred earlier that day, and that the witness had made factual admissions and that statements were made to the witness by the court and the prosecutors acting in concert about the amount of time Mr. Copeland would be held in custody on the contempt. So they were back there bullying him. They had him back there hemmed up, and they were trying to force him to testify. Let's keep going. The court denied Brian Steele, Young Thug's request for the transcript of the meeting and denied the motion, the timely motion for the mistrial based upon this improper and illegal secret meeting which violated Jeffrey Williams' constitutional and statutory rights. So they saying, in layman's terms, not only did you have a secret meeting, not only did you not want to turn over the transcript, but you violated his rights by holding it in the first place. You shouldn't even had a meeting. Now we can't even get the transcript to see what happened in the meeting. Oh my goodness. So we know Mr. Williams, he's entitled to a fair trial, fair tribunal, a fair judge that's not as crooked as a snake, ethical prosecutors. He's talking to you, DA Love, and the right to be present at every critical stage of the proceedings under the Georgia Constitution. Not only the Georgia Constitution, the United States Constitution. And then obviously the video we seen when Brian Steele was held in contempt, he put that in there as a link. I never seen a link put in a motion before. Okay, the rules state, this is the rule about secret meetings. It prohibits, rule 4.1, prohibits secret communications except as authorized by law or by rule. Judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Secret hearings are only authorized in the case of extraordinary matters such as a temporary restraining order or a temporary injunction. In other judicial hearings, both parties, both Judge Glanville, not one, should be notified of the hearing with an opportunity of attending and voicing any objection that may be properly registered. Wow. Oh, Brian Steele filed it. Brian Steele say, I'm filing. That's why he went up there at the end of court. He said, I'm going to put it in your hands so you know it's real. Apparently, Kayla is talking. Oh, so Kayla is talking. Glanville played the wrong hand. It looked like it's getting ready to bite him. Come on. It's getting ready to bite him. Golly, Kayla. If Kayla talking, it's going to be some trouble going on now. Big time. All right, let's see. So the rule states that judges shall accord to every person who has a legal interest in a proceeding or that person's lawyer, so that's Young Thug or Brian Steele, the right to be heard according to law. Judges shall not initiate, permit, or consider secret communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding. And there's a few exceptions. And it's some exceptions down here. The judge reasonably believes that no party will gain a procedural advantage, a tactical advantage. That, I mean, obviously, this is an advantage when you're back there pressuring a witness. And B, the judge makes provision promptly to notify all other parties of the substance of the secret communication and gives the parties an opportunity to respond. So the judge could have said, you know what? Somebody came to the back and they asked for a secret meeting, and I didn't know what it was about. But soon as I found out what it was about, I immediately notified the other attorneys. I stopped the prosecutors and said, nope, we need the other side in here. But Judge Glanville didn't do that. He said, I'm not going to tell them about the meeting, and nobody in this room is permitted to let them know we had a secret meeting. But guess what? It got leaked out. And the judge is trying to figure out who leaked it. And it gives a few more exceptions. The judges may obtain the advice of a disinterested expert on the law. So if the judge don't know what he's doing, he can go get advice from another judge or somebody else. That's not a secret meeting that will affect anybody. They can consult with other court staff and officials. I mean, that's not a big deal. Judges may, with the consent of the parties, confer separately with the parties or their lawyers in an effort to mediate or settle pending proceedings. So obviously this don't apply because they did not have consent of the parties. And obviously they didn't have consent because nobody from the other side, Young Thug's team, even knew that this meeting was going on. They may can have secret meetings. It's another exception when it comes to temporary protective orders, arrest warrants, search warrants, stuff of that nature. Drug courts, mental health courts, veteran courts. That's basic stuff, but nothing this extreme where a judge will be allowed to have a secret meeting in the dark. Brian Steele said this court violated USCR 4.1 and the Georgia Code of Judicial Conduct 2.9. The court has joined the prosecutor's team. The court has joined. The judge took off his referee whistle. He said, I'm not a referee no more. He put on a prosecution's team jersey and start playing with the other team. You can't make this up. You cannot make this up. And not only did he put on their jersey, he is biased against Young Thug. Well, hell, he been biased since the trial started. Let's be clear. They've been holding him without a bond for 2 years. And he's favorable to the prosecutors as he demonstrated on June 10th, as well as throughout the pendency of this case. Wow. Then Brian Steele said, Judge, let me see. Tell me about the meeting. Let me see the transcript. Guess what? The trial court, Judge Glanville, rejected Brian Steele's request for the information about the unlawful secret meeting. And the court denied Brian Steele's motion for a mistrial. But guess what? He didn't stop there. Instead, the court stunningly, he might have stunned you, Brian Steele. He didn't stun me. Stunningly, the court demanded to know how Brian Steele came into possession of the information about the secret meeting. He said, I want to know how you found out about it. Yeah, I was in the back room with DA Love. Boy, that's nasty work. Yeah, I was in the back room with DA Hilton. Yeah, I was in the back room with the security guards. And we were all hemming up Kenneth Copeland and Lil Woody, trying to make him change his mind and make him testify, where he admitted to killing Donovan Thomas. But we'll get to that. The prosecutors, DA Love, stunningly sat mute. Again, I'm not stunned. I know how they play. And permitted this injustice to occur and for the court to attempt to intimidate Brian Steele. Judge, how you thought you were going to intimidate Brian Steele when he showed up with 25 lawyers the same day? This has become a Lifetime movie. Come on. Not a Lifetime movie. Lifetime isn't going to get down and dirty. No, they ain't going to get dirty enough. We got to get all the way to the T. Okay, let's go. Later, Love, a lawyer currently employed with the Fulton County District Attorney's Office, where Fonnie Willis is the boss, argued that the secret hearing with the witness Copeland was ethical, just, and proper, while the other prosecutor, DA Hilton, remained mute. She remained mute because she knows she had messed up, and she later on, it was found out that she was crying in court because she knew she was caught red-handed. Well, what's that song by Mr. Biggs? When he caught that girl, he said, what the hell is going on between the sheets in my home? She said, baby, wait, let me explain before you start to point your cane. He said, girl, I'm about to have a fit. Oh, okay. Brian Steele declined to join the antics in ignoring rules and ethical provisions and declined to provide information requested by the court relying on the state bar rule of professional conduct. So what Brian Steele said, I'm not going to do the illegal stuff that y'all going to do. I'm not the one that's going to be busted when the SHIT hit the fans. I'm trying not to cuss, because it's about to hit the fans now. It's about to hit the fans, if it already hasn't. Man, let's keep going. So Brian Steele said he's not going to violate his rules. He's not going to lose his law license because Rule 1.6 tells him not to. Rule 1.6 say a lawyer shall maintain in confidence all information, not some, all information gained in the professional relationship with the client, including information which the client has requested to be held. What is this? I don't even know how to pronounce this. Or the disclosure of which would be embarrassing. Invalidate, maybe invalidate. Let's sound it out. I'm so hyped up right now. Anything that's embarrassing, the client can say, do not tell anybody about it. So is he hinting that Young Thug got the information first? And nothing could be released unless the client gives informed consent, except for disclosures that are allowed to be released by law. So unless Young Thug say you can release it, you can't release it. Okay, we got an interview today at 6:30 with Caleb Bumpers. Oh, okay. What time is it now? Is it? I don't know what side is Miss. What's her name? I think Miss Sylvia on the East Coast, right? So you're meaning in like 15 minutes they having this meeting? If she got Kayla on in 15 minutes, then I pull up Miss Sylvia's channel right here and we can all listen to it together. I keep my eye on it as I keep going through this salacious motion. Okay, so Rule 1.6 just basically talk about the attorney-client privilege. We ain't got to go through all of that. Basically, whatever your client tell you, the lawyer can't say nothing about it unless they are required to by law. It's a few exceptions. So, you know, if a client say, I'm on my way to go kill somebody, okay, now we're duty bound to at least try to make an effort to stop that. So, hey, my client's on my way, on the way to go, then you can say something. But if your client come to you and say, I've already killed somebody, then there's no outstanding emergency, right? Because that person already is deceased. So there's no need to reveal that confidence. Okay, she's in ATL, so she's on the East Coast. So that means I'm gonna pull it up. We can watch it here together if y'all want to. Okay, so let's go. The court ignored the ethical rules relied upon and continued to demand Brian Steele to reveal the source of the information, claiming that the way that Brian Steele obtained the information was somehow unlawful. How you know that, Judge? You don't know how he got it. And basically accused Brian Steele on the record of potentially acquiring the information through eavesdropping. He said Brian Steele had his ear to the door. And obviously that's a crime. Say what now? Say what now? Eavesdropping. Hold on. in response to these salacious, oh my goodness, impermissible accusations and permissible demands of the court, Brian relied on the ethical mandates of Rule 1.6. Brian wasn't worried about no Rule 1.6. Brian just wants to tell his damn source. Let's be clear. If somebody come to you and tell you something as a lawyer and you promise them you're not going to say nothing, then you're not going to say nothing, because what happens in the future when you burn your source, then they quit telling you information. So you don't ever reveal your source. I don't care how much pressure they try to put you under. But Brian still say, Rule 1.6 said I can't tell you, Judge, even though I'm not going to tell your ass anyway. And then Brian still says, since you're accusing me of eavesdropping, I have a Fifth Amendment right to remain silent and decline to provide the source of the information which had been proffered. The court, this is a good sentence right here. Look at this last sentence, y'all. Look at this last sentence. The court is so biased, not biased, but they so biased against Brian Steele and Jeffrey Williams, ain't no and Jeffrey Williams. The court ignored all laws and pursued contempt penalties in an attempt to intimidate Brian to violate the law in order to continue to help the prosecution convict Jeffrey Williams and others. So let's be clear. The court is so biased against Brian Steele. He don't like Brian Steele, so he sent him to jail. And he's definitely biased against Jeffrey Williams. How do I know that? Because he's working hard to put Jeffrey Williams in prison. You can't tell me he's not biased against Jeffrey Williams, because the outcome of this trial is whether Jeffrey Williams will go home or go to prison for up to 20 years. So he's definitely biased. So yeah, they can take that and or out. They can just say and. Let's keep going. The court issued a written order of contempt and incarcerated Brian Steele, imposing the maximum sentence of 20 days. But then the Supreme Court stepped in. The Supreme Court said, hell no, Judge Glanville. You thought you was running something in Georgia, but we really ought to and somebody know what I'm talking about. Y'all seen that movie Joe Clark on the Lean on Me? And Joe Clark thought he was the HNIC, but the superintendent said, no, contrary to popular opinion, he said, I'm the HNIC. The Supreme Court said, hold on. We the HNIC, Glanville, not you. And they granted a writ to address the appeal of contempt order and has granted Brian Steele a supersedious bond. So basically they said, you're not going to jail for 20 days. Glanville gonna go to jail before you go to jail. Let's be clear. That's what the court said. The court violated the law by failing its duty to recuse from presiding over this contempt proceeding. So the judge violated his oath again. You have a contempt proceeding, you bring in a separate judge, but this judge would not let it go. In such proceedings where the announcement of punishment is delayed and where the, contumacious conduct was directed, God, he using all type of words, he's so mad. Contumacious conduct was directed towards the judge, or where the judge reacted to the contumacious conduct in such a manner as to become involved in a controversy. Yeah, his judge, he involved. The judge may give the attorney notice of specific charges, but the hearing, including the attorney's opportunity to be heard, must be conducted by another judge. Brian still said he want a judge that has clean hands. He said, Judge Glanville, your hands are dirty. Your robe is dirty. Hey, what's going on, Michael? Shout out to Michael Williams. Not only that, your courtroom is dirty. It is literally dirty. They got a deep cleaning today because apparently COVID's in the air. So we got a lot going on in Judge Glanville's court. The internet not working. The AC not working. That's cruel and unusual punishment. Oh, appreciate it. Same to you. Appreciate it. We were on earlier today for about 6 hours. As soon as we got off, this breaking news that came out about the judge has been formally accused of collusion with the prosecution team. Okay, in a case called Schoolcraft, let me see if y'all can see. Oh, okay, I didn't go back. Schoolcraft, the court, in the case of 2005, the court involved itself in proceedings by joining the prosecution and conducting the secret meeting that violated Mr. Williams' rights. So basically, they said the court joined the prosecution. He took off his referee whistle. He took off his umpire mask. He took off his umpire mask. That was the school teachers, I think. I don't know which part. Oh, okay. You're talking about the okay. This created a conflict of interest for the court because its own unethical conduct is questioned and at the heart of this issue. And then it goes on, the court then compounded its abuse of power by presiding over the very contempt hearing where its own rules violations prompted the controversy. So Brian said, hold on, you broke the law, Judge. I questioned you about it. You got mad at me. And now you want to preside over the same hearing, over the hearing to hold me in jail for the maximum 20 days? Make it make sense. What that boy say? The one that was his co-defendant was the Gunna. Gunna got a song that say, fuck you mean. Okay, the court should have recused and allowed the contempt proceedings to be handled by a separate court. Further, the prosecutor sat mute. Yeah, they're going to sit mute, especially Love. And what he thought the prosecutor was going to jump in and save the day for him or what? The prosecutor sat mute and permitted the court to attempt to interrogate and intimidate another member of the bar who reported a violation of a law and also promoted the court's wrongful conduct by asserting that the secret meeting was proper. The judge became the coach of the other team. The referee then went over and put on one of their jerseys, and he became the coach of another team. Oh, hey, Yvette, thank you for hopping on. I was asking about you earlier. You're the former APD officer, right? That we're going to try to get up and speak one day whenever you had time. Oh, I know I just put all your business out there. I know I've seen your comment. I think it was Yvette. Correct me if I'm wrong. All right, let's keep going. The court denied Young Thug and Brian Steele their due process rights. How you going to deny somebody their due process rights? As Brian Steele has a right to adequate notice and to be heard. He has a right to call witnesses at a hearing and to be represented by counsel for the entirety of the contempt proceeding. And he has a right to learn of all the facts and circumstances of this critical stage of the proceeding that occurred in his absence, ex parte, aka secret meeting. He said he got a right. Then he goes on to say, the court abused its authority by holding Brian Steele in contempt for refusing to divulge privileged information and for protecting Young Thug's constitutional rights to due process, a right to a fair tribunal, a right to a fair trial, a right to be present, and effective assistance of counsel. This court's refusal to acknowledge these rights and protections has created an unfair tribunal based upon bias against Jeffrey Williams and his counsel and favoritism to his girlfriend, the prosecutor, D.A. Love. Y'all know I'm not lying. Thank you, Michael. If y'all don't mind hitting that like button and subscribing, if y'all haven't already, I appreciate that. If we can get to that 1,000, that'll be good. But before we get to that 1,000, we finna get to the money. We finna get to the meat of this motion. Let's go. Motion to disqualify and recuse Judge Glanville is timely filed. It's timely filed according to Rule 25.1, and it mandates that the time for filing a motion to recuse shall be not later than 5 days after Brian Steele first learned of the grounds for disqualifications. The Honorable Supreme Court of Georgia has taught that a motion to recuse is timely filed if it's filed within 5 days. Thus, the motion is timely filed as a reason for the disqualification. Recusal was first learned on Monday, June 10th, 2024. All right, so let me see the calendar. Okay, so June 10th and today's June 17th. So I'm assuming when he says 5 days, it was last Monday, so 5 business days. So he's timely. He's timely, Judge. You can't throw it out because of time. All right, let's keep going. The record also reveals numerous instances that happened at the trial when the judge's behavior appears to have been biased against Jeffrey Williams, Young Thug, counsel Brian Steele, and partial in favor of the state. So you can't be partial, Judge. You got to be impartial. It was another trial in 1985 that a trial judge derogatory or prejudicial statements and demeanor will be considered so long as a reviewable record has been completed. So that's why everything you want to the appeals court to see, you got to put it on the record, because if it's not on the record, the appeals court will not see it. The appeals court, they don't watch the video like we watch the video. They don't listen to voices like we listen to voices. You just go in there with a stack of papers, and then the stack of papers, you send it over to the appeals court, and all they do is read. They can't hear the sound of your voice, or whether you was yelling when you said something, or whether you was quiet. So, hey, thanks, Tiff, for joining again. I mean, you have to put everything on the record. Okay, so Brian Steele said, the record reveals other instances too where the trial court wrongly berated counsel in front of the jury. Yeah, so the judge called Brian Steele unprofessional in front of the jury and said he was unprepared. You do not say that to a lawyer while the jury is out there, because that can unfairly make them look negative towards Jeffrey Williams. But they did that on purpose. Of course, the judge is in cahoots with the prosecution, said Melissa sold Moxie Foods. The prosecution did what? Oh yeah, they just that's dirty. And then Brian Steele said after a number of such incidents, Jeffrey Williams, Young Thug's counsel, out of the jury's presence, moved for the trial judge's recusal and sought a mistrial on grounds that the judge had shown a lack of objectivity and he had displayed bias against Jeffrey Williams and his counsel. See, they took out that and/or mess. Yeah, and his counsel, and had assisted the prosecutors in making their case before the jury. So what he said is, you helping them. They can't win on their own, Judge, so you are officially jumping in to try to help them. And that ain't right, obviously. Put your whistle back on. Is it too late now? Y'all think it's too late? Could he put it back on? Could he put his umpire equipment back on after he done joined the other team? Judges have an ethical duty to disqualify themselves from any matter in which they have a personal bias or prejudice concerning a party or an attorney appearing before them. In this regard, a trial judge shall avoid impropriety and the appearance of impropriety. So that means, Judge, not only can you not do wrong, but even if it looks like you're doing wrong, you need to bounce up off the case. Let's see. The Code of Judicial Conduct provides that judges should disqualify themselves in a proceeding in which their impartiality might be reasonably questioned. I think we can all say that we have reason to question his impartiality. including but not limited to instances where the judge has a personal bias or prejudice concerning a party's or a party's lawyer. Within the context of this requirement, the word should means shall. So the code provides that judges shall. What shall mean? What y'all think shall mean? Okay, 7:30 start time, so I got time. Okay. So yeah, 7:30. I wanted to jump over or share my screen to Miss Sylvia's channel so we can see the interview of one of the people that was in the secret meeting, where she gonna hopefully tell all, so we can get to the bottom of what was really going on. But yeah, so judges shall disqualify themselves. Y'all know what that word shall means? Let's say you get a ticket, and on the ticket, you were speeding so fast, and they say you're you shall appear. Does that sound like a request? Oh, do I have to go? Maybe I don't have to go. You shall appear. You take that as an invitation if you want to. You'll have a warrant off of your arrest. And guess who's going to be signed by? Judge Glanville. So exactly. That ain't no option. I mean, within the context, should mean shall. The Supreme Court is mindful of the extraordinary pressures attending a criminal trial of this magnitude. On the one hand, defense counsel is obligated to vigorously defend Young Thug against all charges brought by D.A. Love. Likewise, D.A. Love must effectively and ethically, them ain't even in her vocabulary, present the state case to the jury. At the same time, the trial judge is charged with ensuring that the rules of evidence and procedure are followed and that the proceedings are both orderly, ethical, and fair. See, when I got off the line the first time, I didn't even put my phone back on silent. I thought we was done for the day. So we know nothing's, if you look at Ms. Love, nothing says ethical or fair about her. When these several interests come together in the courtroom, during the trial, disagreements between the bench and the bar are to be expected. Yeah, it's not uncommon to have disagreements with a team. Like say basketball, you're gonna have a disagreement with the referee. He may make a bad call. That's normal. But what you cannot allow is for the referee to just put on the other team's jersey and play against you while he's refereeing against you at the same time. The instances discussed above and in the attached Exhibit B, joint affidavit. Oh, they didn't fill out an affidavit on his. Oh, yeah. They didn't fill out an affidavit. However, represent more than mere friction. This ain't just friction between zealous counsel and a diligent jurist. The judge's conduct, as discussed above and herein, created the impression that he harbored an inclination to be biased against Jeffrey Williams, aka Young Thug, and his counsel Brian Steele, and partial toward the prosecution. I'm gonna take a breath right there, because golly. Higher courts need not decide whether such bias and impartiality actually existed, because judges are ethically bound to disqualify themselves whenever their impartiality might reasonably be questioned. Well, Judge, we questioning you. Because we know that you ain't no damn good. Okay, including instances where the judge's behavior could indicate that he has a personal bias or prejudice concerning a party or a party's lawyer. So we pretty much had that part. As explained, Judge Glanville in this case participated in the game. He participated in a secret meeting. He in the huddle. He over there in the huddle with the other team, with the prosecutor, in which he assisted the state to influence a witness to testify against Jeffrey Williams. Somebody said Miss Love acting like she wants Fannie Willis' job. And then Erica said, no, she's not acting. No, she not acting like she wanted, or the old folk used to say she made like she made like she wanted. No, she wanted. All right. These actions certainly raise reasonable questions concerning the judge's partiality and bias. Because the trial judge, Judge Glanville, impartiality is reasonably questionable, it is error to deny Young Thug's motion for recusal. The highest court has set forth at least 3 circumstances in which recusal of a court is necessary on the ground of mere appearance of bias, even in the absence of evidence of actual bias. So what they're saying is, we don't even need actual bias. But if you look like you up to no damn good, Judge Glanville, we can kick you off. Young Thug does not waive that actual bias has been objectively shown throughout the trial, as well as on June 10, 2024. But for simplicity, the appearance of bias is also met. So what he's saying is, Judge, we don't have to prove that you are no good. We just have to show that it looks like you are no good. But at the same time, we're not waiving that you are actually no good. So even though we don't got to prove that you're no good, we're not waiving that issue. But to make it simple, we're just going to say it looked like something's not clean in the water. You look like you was back there with Miss Love in the dark, in between the sheets, under the cover of night. Okay, let's see. So we got 2 of these circumstances at bar. The third circumstance is in which recusal is required on the grounds of mere appearance of bias, absent evidence of actual bias, and when a judge has direct personal substantial interest in reaching a conclusion against the litigant. I think that applies too, based upon information to believe this. Okay, it looks like there was a footnote that was cut off, so maybe he continued it at the end. But first, mere appearance of bias requires the recusal of a judge when the judge becomes embroiled in controversy. Ain't he embroiled? He in the what they call, he in the thick of it. Oh man, he in the thick of it now. Okay, let's see. So a 1974 case showed it was a relationship between a judge and a lawyer was such that due process required the recusal of a judge. They didn't win and pulled a 1974 case out on them. As shown in Exhibit B, I guess we get to the exhibit at the end, the court favors the prosecution and is attempting to sabotage. Y'all see that strong language? Do y'all see that strong language? They so mad at Judge Glanville that they are directly calling him out. See, somebody else had told me this earlier, but I didn't get a chance to see it. I got to go back and see. Somebody said they were doing They had ear signals and baseball signals. They had all type of stuff going on. I got to go back and look. What your grandma say? My grandma always taught us to be careful when trying to dig a grave for someone else, to make sure you dig one for yourself too, right? And sometimes you ain't even got to dig a second grave, because the ditch you digging might be the one you fall in. So so your grandma sure know what she's talking about. Georgia courts have followed this demand for recusal when the judge becomes embroiled in controversy. And they just list some law here. It requires, look at this, 2003 due process requires that the trial judge cannot be both the prosecutor as well as the judge in our judicial system, and thus must be recused. They say, judge, you can't play for the damn team and be the judge in this case. You can't play for the team. Look at that. The judge cannot be both the prosecutor as well as the judge. Is that something that you have to tell somebody? I had a judge like this one time in one of my trials. He was so pro prosecution. I had told my I don't know who was with me that day, legal assistant of my client. I said, damn, he might as well go sit over there with him. Every time I say something, overruled. When they say something, sustained. I was like, damn, you might as well just get up and go sit over there. And we end up winning. And he gonna shake my hand after the trial. That's a good trial. Yeah, no thanks to you. Let me see. So a lot of this is just the law. We know what the law, that we would have read the law. The judge can't be in it. Okay, we got a situation right here. Our highest court explained that the Constitution prohibits a scenario where the judge ordered witnesses to appear before him or her in order for the judge to gather facts to determine whether contempt proceedings should occur, and then the same judge presides over the contempt trial. This is because such a judge grand jury arrangement caused by the judge to become part of the accusatory process, and thus the judge should be recused from further dealings on his case. Here, see, first you give the law, right? And then you apply the law to your specific facts. And this is what Brian Steele did. He said, here, Judge Glanville has ordered Mr. Copeland's lawyer, Miss Kayla Bumpers, who got an interview today in 45 minutes, and others to appear to give information on a contempt proceeding. Same is against the law. So hopefully y'all be around, because I have it upon information and belief. Information and belief that the lawyer for Kenneth Copeland will be going live today at 7:30 Eastern time, 6:30 Central time, and would that be 5:30 Pacific? What do you say? Can you be Pacific? Can you be Pacific? So maybe we get to hear from the attorney for Kenneth Copeland so we can figure out what the hell went down in that back room. And I hope it's good, because I had to put my tie back on for this, Miss Kayla Bumpers. I done threw this tie off. I was eating and finna sit down somewhere, and when I got the email saying that this motion was up and hot off the press. So I hope it's good. I hope it's good, Kayla. Importantly, a trial judge has a duty to recuse itself sua sponte. What that mean? That mean on its own. Should nobody have to tell your grown ass to recuse yourself. You should do it sua sponte. You should do it on your own. because you know that you corrupt. And see, I practice in Texas. I don't practice in Georgia. But even if I was in Georgia, I'm gonna call you out. Hell, I done called out some Texas lawyers, Texas judges. Oh hell, they all in cahoots. I don't. Hey, when your client's rights and life is on the line, you go all out. You don't leave nothing on the table. You don't give them one single inch. And I'm hoping I'm talking to a future lawyer on this chat. Don't give them 1 inch. So a judge must recuse itself on its own from any proceeding in which the judge impartiality might be reasonably questioned. So we got that. We know he biased. We know he got to see if you're not fair-minded. Today they had a motion to not allow all the videos in, and the judge let him in anyway. He did the dog and pony show like he wasn't going to let him in, but in the end, no, what I'm gonna do is, no, it's Miss Sylvia's channel. So what I'm gonna do is, when she go live, I'm gonna share my screen of her live, and that way we can watch it for those who are still here. And if some of y'all follow Miss Sylvia, y'all can just watch it directly from her. But for those that do stay behind, I'll show it too. We can watch it together. Damn, went from handing out sentences to finna be getting sentenced, right? Pick them up. Pick them up. There you go, bro. Shall is must. Take it as an invitation if you want to. You're going to be sitting in the county jail. As sad as it is to say I don't want black attorneys to be disbarred. But if they dirty, they low, what's that movie? Low down, dirty. Shame. You got to go. Hell, at this point, Glanville, quiet as it's kept, his career, he didn't work all his life, military service. I mean, he done. In a sense, that means that Miss Kayla Bumpus need her law license a lot longer than Judge Glanville. If y'all get what I'm saying, he's at the end of he got more years as an oval. So I got more years behind me than in front of me. So he got more years behind him than in front of him. I mean, if he not working anymore as a judge, so what? He done made some of his money and got retirement. He can sit at the house. But he better make sure he's not sitting in the jail cell. I know that. They have favorites and it's sad. What was your question? Did she have a question? Okay, 7:30 start time. Did I miss your question? I don't think I see it. He gonna be pissed off tomorrow. Yeah, if you can copy and paste it for me again, then I can read it. That's what you're supposed to do, all right? On a real note, this is sad. If they would do this in this type of trial, can you imagine how many poor people they have done this to? Oh yeah, they would try to bully, especially the public defender's office. If you don't got a strong one in there or somebody that's gonna stand up to them. And I've seen public defenders come up to me after the case is handed off after I'm hired. They say, hey, I was trying to work this case, but the prosecutor won't budge. I'm like, I got it from here. Let me see the case file. So yeah, it happens. Let's keep going. Okay, to warrant recusal, the alleged bias must be of such nature and intensity to prevent the complaining party from attaining a trial uninfluenced by the judge's prejudgment. The judge's prejudgment. And I think it's safe to say the judge has prejudged this trial. And I go back again to the issue of bond. He already in his mind think they're guilty. He won't release them on bond, which they are entitled to. And then the prosecutors say, well, they're dangerous. We can't release them. But the main ones who are the most dangerous ones, the ones that supposedly, allegedly admitted to killing people are out, either not charged or on probation. but yet they're so dangerous where the other 6 cannot have a bond. To warrant disqualification, Brian's Steele affidavit must support the charge of a bent of mind that may prevent or impede the impartiality of the judge. A bent of mind. I haven't heard that phrase before, a bent of mind. But we know the judge is hell bent on conviction. He hell bent. Well, you say Washington now say you don't need the bar. They granted them pleaded right. If they're so dangerous, you know, judge, you can't let these people off for the next 20 years. They're so dangerous. But if they sign a piece of paper, if they sign on a dotted line, let them out tonight. Let them out after court. Let them out immediately. Because there's no doubt in my mind, if any of those other co-defendants in court would have signed the dotted line, they would have been at home today. But if they said, no, I'm not signing for something I didn't. No, I'm not signing a dotted line. Sign a dotted line for what? Did the judge allow the prosecution to open their own door with using the interrogation video? Well, kind of in a way, because Kenneth Copeland is saying, Woody is saying that he don't remember anything from 2015. How many of us remember something from 2015? I'm sure none of us remember stuff with that great detail. So normally before trial starts, the prosecution will show the video to Woody or to any other witness. Just as defense attorneys, we're going to show you the video before trial. We're not going to put you up there blind. But what the prosecutors did, they did not show Woody the video before trial, his interviews before trial, because they wanted him to get on the stand and say, I don't know. Because when you get on the stand and you say, I don't know, or you get on the stand and you contradict something from that interview in 2015, guess what? Now they can bring in the whole video in the court and play the whole entire thing. And that's what the defense said. Judge, they didn't show him the video before trial. And now that he doesn't remember, they're using that as an excuse to bring the whole video into the trial. So it's been a lot of low down dirty stuff going on. Right. There you go. That's why, I think it was the defense attorney, Matt Shard. He basically said, you can't have it both ways. You cannot hold the evidence and don't show it to him and then get on the stand and say, aha, he don't remember, judge, or he said something different in the video than what he's saying now. So now we get to play the whole video. Prosecution played by not preparing their witness. I get it. Shard says that their whole game plan so that they can pull this every time. Exactly. To say the least, this is nasty work by the prosecution of the Fulton County District Attorney's Office. I don't think I'm gonna be able to fly through Atlanta Airport no more. I'm talking so much noise about them, they're gonna be waiting on me at the gate. Hell, if they can find me, it's so many damn gates. It's so many gates. Hell, they ain't gonna be able to find me in there. So it's just some more law. Okay, here we go. In the case at bar, in the case at hand, in this case, Young Thug's case, the court met secretly with prosecutors and a sworn witness, Woody. And guess what? Not only that, they never. I ain't got on screen up. Let's go back. In the case at bar, the court met secretly with the prosecutors and sworn witness Copeland, Woody, and never intended to reveal the meeting had even occurred to Jeffrey Williams, Young Thug, or his counsel, Brian Steele, or Keith Adams, or to anyone else for that matter. Put that in there, or anyone else. Hell, they want to keep this a secret as long as they could. The court has become part of the executive branch, and that's the DA's office. by prosecuting Mr. Williams. They said the court has become part of the DA's office. Moreover, more so, furthermore, additionally, the prosecutors have abandoned and violated their ethical duties by engaging in the secret meeting and sitting silent while the court held Brian Steele in contempt and failed to reveal any Brady evidence from the meeting, including the fact that the meeting occurred. So we know Brady evidence is any evidence that can show the innocence of a client. So you cannot withhold the evidence of that meeting. Yeah, you didn't tell me the meeting happened, but now I know it happened now with the transcripts. I'm required to have that transcript because that transcript could free my client. Y'all saying my client killed Donovan Thomas, aka Nut, and Woody allegedly admitted to killing Nut in the back room. So if Woody said he killed him, then obviously I need the evidence to prove my client, Young Thug, did not. The bad thing is with others taking plea deals, because they know how dirty this circuit is in Fulton County, it makes all the others look bad to question, are they all guilty? Yeah, this is true. And that's why you try to get people on the jury that haven't heard anything about this case, that don't know nothing about the other people taking plea deals. I mean, you know, for whatever that's worth, some people say they don't know and they know every detail. Defendant might be celebrating their own freedom on June 19. Shout out to Juneteenth, where slavery was illegal, and that information was withheld from Texas for 2 years. So they had to work for 2 extra years for free, endure slavery after they were already set free. It took 2 years from a boat to get here on the shores of Galveston, Texas. Shout out to Galveston. That's a good place to go to the beach. And once they landed, they said, "Hey, y'all free." And then, you know, obviously they're probably like, you know, we're free. What do we do now? Because they didn't have no type of system set up for once they were free. Okay, here we go. The court and the prosecutors, teammates. The teammates should not be working together, but they are. They teaming up to gain an unlawful advantage against Mr. Williams. Y'all got to understand, he's really calling the court out in your face. Y'all seen when Javonte Davis just knocked the old boy out on Saturday night? And Ryan, Ryan, the one he had fought before, Ryan jumped on the ring and said, "Hey, Ryan," he said, "Hey, Javonte, I want a rematch." Sometimes you got to let them know. I'm not going to send my manager to tell you. He said, "I want a rematch." So Brian Steele, when court was over today, he went to the judge and gave the paper to him. He said, "No, you ain't gonna read it when you get your e-file, your email tonight. No, bastard. I want you to read it right now." And in the words of Gunna, "Fuck you mean." My God, I wanted them to let Thug out for the ring walk. Yeah, that would have been wild. That would have been good. Young Thug trial is constitutionally fractured. I don't know if it's fractured. I think it's broke as hell. The bone is broke. The bone broke. He can't play no more. You got to sit him out. Unfair and lacks all constitutional, statutory, ethical safeguards and protections of due process of law. The court is biased against Jeffrey Williams and his counsel. See, when we first started off, they were saying against the accused and or the counsel. Now he done figured it out. The more he typed, he said, "No, ain't no and or. He biased against me and my client. Let's just be real." always say no honest person, intellectually honest person could believe that coercing a witness Copeland to testify in a star chamber setting meets constitutional muster. Oh, what he's saying, Judge, you not intellectually honest. He said you a evil son of a gun. And that's the clean version. The court isn't just corrupt, it's downright evil, says Thomas. This court has failed to follow the lawful path. Well, we already saw this morning that D.A. Love said this is the law of the jungle. She said she ain't following no damn lawful path. It's the law of the jungle. That's what she said in her opening statements. Instead, the court, Judge Glanville, has unlawfully become the prosecutor. Judge and grand jury biased, partial, potential sinister, and thus must be removed from this case instantly. Now he should have gave him another name right here because he has become the prosecutor and the judge. They need to call him what they call him, DA Judge. What's a good name for him, y'all? What's a good name for him? DA Judge. Mix them together. Prosecutor Judge Glanville. See, they don't know how to write. Hey, talk about you like a dog in emotion. I bet you Glanville at that damn house so goddamn mad. YFN Glanville. YFN say they don't even want him. I bet you he's so goddamn mad at that house. I bet you he yelling at Jack, his dog. He yelling at Jack. Somebody go get Jack. Somebody go get Jack from that man's house. He finna knock the hell out of Jack. His PTSD finna flame up tonight. We got about 27 more minutes, and then we're gonna pull up the stream of Miss infamous Sylvia. Shout out to Miss Sylvia. She be in the courtroom every day with her own camera. I know that's right. He better not be effing with Jack. Oh, Jack. Bite the dog out of him. Come to court tomorrow with his hand bandaged up. Oh, okay, Katie Matthews. Katie Matthews say, then black attorneys, white ones neither, I'm going to add that, should not violate defendants' rights. They wouldn't want to be railroaded if they were on trial. Color doesn't matter in this instance. Come on, Katie. I don't care what color you is. And I mean, I get the sentiment. I mean, obviously, we have to jump through more hoops. And when I say we, I'm talking about people that came way before me. So I know it's more disheartening to see attorneys that look like me, or judges too, Judge Glanville, be in trouble like this, especially what we have to go through back in the day to get here. So I get it. But at the same time, I don't care what color you is. I done had judges that look like me that I can't stand to this day. And if y'all watching this, Judge, you know exactly who I'm talking about. And then I had judges that didn't look like me. And I'm talking about law-abiding, law enforcement, prosecutor type of judge. They wear the cowboy boots to court. And guess what? Turned out to be the best judge I could have had on the case. So you can't go by looks. I mean, we pretty much learned that a long time ago. She said, bark twice tomorrow if you need rescue. Say what now? Say what now? All right, let's keep going. We got some time. We got some time. And then, so for those of you who just popped on, it's been brought to my attention based on information and belief. We get to hear today from Woody's substitute attorney, and she's been ordered to appear in court next Tuesday to show cause of why she shouldn't be held in contempt of court. So Judge Glanville, he better be real careful because Brian took his time writing this motion, and I wouldn't be surprised if the appellate courts or the Supreme Court or some people on the court probably told him, hey, this is what you need to do. Yeah, file that first, and they got to go through him and then get it back to us. Hey, I wouldn't be surprised. Katie, at Kathy or Katie, oh, I agree. It's just sad on so many levels. This man is a chief judge and he's as dirty as they come. And he's ex-military. He learned from the best. Hold on, do we got any military representation in the chat? And that's probably what he think he's still on. He think he's still in the military. This ain't martial law, Glanville. Somebody said he was a weekend warrior in the reserves. Well, he still serves, I guess. He still, yeah. My best friend's military, and he served. He ain't out there hiding behind a computer. I remember when I first got barred. I remember people from the military were coming to the school. You get ready to take the bar exam, and hey, you want to come to the military and be a part of JAG? Hell no. Hell no. Y'all ain't finna have me marching and doing all that extra stuff. But shout out to the military folks. Since Woody took the stand, I've been telling folks there's no way this case make it to his cross examinations. Yeah, especially when she still have 4 more interviews to do and 11 jail calls. Welcome back to civilian life. Yeah, welcome back, Judge. Come on back. And I think he's been a judge since a civilian judge for 20 years. Kathy is sad because I've seen black attorneys walk into court and be asked, are they being represented? They get treated like they are on trial, but I agree. All need to do right. No backroom deals. Yeah, that's true. I can't tell you the amount of courtrooms because I practice in a lot of counties in Texas. Oh my God, some of them. Can I see your bar card? I'm saying, why you want to see it? Because you ain't got one? I told that to the bailiff. Oh, that bailiff turned so red. He was so mad at me. And then my client said, hey, this is my this is my lawyer. And he was like, well, sometimes we get people in here acting like they're attorneys, so we just beat the check. I said, dude, come on. Ain't nobody acting like they're no attorney. And if they were, they ain't dressed this damn good. And by that time, the judge heard we had already settled it. He was like, oh, okay, I didn't know you, but now I'm going to remember you. I see you remember me next time. And then the judge going to jump in it all late. What's going on back there? We way in the back. What's going on back there? What's going on in my courtroom? Judge, first of all, we already got this handled. He don't need help from daddy because we're having a man-to-man conversation. That judge was so mad at me. And if it wasn't for my client, I probably would have just went home that day. He would have had to see me on a different day. But my client was waiting. He was ready for that case to be over with. But the judge, by that time, the judge was all huffing and puffing. So I said, I'm going to go outside and let him cool off. Sometimes you got to let him cool off. And they thought I was gone. And my phone got the ringing. Where he go? Where he go? I'm ready for him. He's next. He's next, with the judge saying. because they thought I was going to leave and report his ass. Judge, I'm not going to report you. I was having a grown conversation in the back with somebody else. The judge thought I was going to go report him. See, the judges know. You don't know who lawyers know. They do me the same way as an aircraft mechanic. Can I see your license? No, can I see yours? Oh, right, that's right. You don't got one. I seen that bailiff the next time I was in that courtroom. He thought he saw a ghost. I said, I want you to ask me for a bar license or a driver's license. I'm gonna go dead off on your ass. Oh. All right, back. Okay, that's enough of that. He was a judge in the military. I'm just killing time, y'all. We got maybe 13 minutes until Miss Sylvia go live. And once she do, I will share her screen on my live so we can watch it together. Still slick for this motion to recuse before YFN Glanville's order of case hearing for the ex parte leak 2. Yeah. I'm thinking what Steele is trying to do, he's trying to stop that hearing from happening, that show cause hearing from happening on June 25th. He's trying to stop that from happening because obviously he don't want Kayla or whoever told to get in trouble. I mean, it makes sense, you know. And she definitely don't want to go to court and lie, you know, under oath, because even if she's cleared of this, you still can't go in there, you know, and lie under oath. So I'm sure he's trying to stop that. Let's see. What happens with this motion? What's next? Let's see. So just some more law. Brian Steele said this court's conduct raises a strong finding that it has become personally embroiled in the case. It is clear even to the casual observer. It say even to TalkThatLaw in the chat. It's so clear to everybody in the world. We had somebody on here from another country, and they said it was wrong earlier today. That this court involvement in this controversy requires this court be disqualified, recused, removed, thrown in the trash can, burned, and started over from scratch from all further proceedings in the above referenced case. And another judge, and it's instantaneous, and another judge wait, which one? Disqualified? And another judge who will be duly exercise the powers of the judicial branch with partiality, clarity, and fairness be appointed to this case. So basically what they're saying is we need a judge in here that's not that's not clouded, his judgment not clouded by seeing this love strut back and forth in her skirt in a high heels. He needs somebody that not clouded by the way she talked to him. She get on him, judge. He changed his mind quick, fast, and in a hurry. Somebody that's not clouded by meeting in the back room secret closet with the prosecutor on the case. I'm glad Brian filed his motion. I was able to get my second win today. I was able to get my second win. It is critical to the functioning of our courts that the public believe in the absolute integrity. Who believe in the absolute integrity of this court? Nobody. We might have a few on the opposing side. If y'all got a different opinion, let me know. If somebody got a camera and a mic and y'all have something to express, let me know. We got about 14 minutes. Let's keep going. Okay, so a lot of this is kind of legalese. It kind of repeats itself. We already went through what the code says. They got an affidavit to remove him. If the motions fall timely. So all this stuff we kind of went over. Rule 211 saying he got to get out of there. They put some case law in there to make it sound legit. That's always a good thing. Put some case law. You're going to file a motion for any of the young attorneys. Put some case law in there. Oh, you got notified, Erica. I didn't know it was going to notify y'all. Because a lot of times when it's so many people on YouTube at the same time, and you have all these other channels out there, like a million channels and these bigger channels, they get like priority, seniority first, because they trying to get that money. They want that ad revenue. They said over here, it ain't monetized yet. It ain't 1,000 subscribers. We're not gonna get no money over there at TalkThatLaw yet. Hey Joe, what do you? Never mind. Oh, that's somebody else. He bet and agreed. The reserves is not the army. I'm just saying. I'm saying too. I'm saying it's a difference day and night. They destroyed Glanville. Okay. Sub to the channel, y'all. Oh yeah. If y'all don't mind subbing, if y'all don't feel offended by my words. Guess what? I didn't do this. I didn't have a secret meeting in my office. I didn't jack up a witness in a corner and tell that witness, even though you plead the Fifth Amendment, you listen at me. You better go up there and testify. Because if you don't, I'm going to lock you up for years indefinitely. You will never get out. That's what the judge tell him. And then the prosecutor, not only will you be locked up until this trial is over, you're going to be locked up until all the other trials are over. And guess what? The prosecutor told him, I'm going to give you permission to lie. She told Kenneth Copeland Woody, I will give you permission to lie and I won't prosecute you. She told Kenneth Copeland he can lie under oath on the stand. She told him. She said, you can lie about anything you want to lie about except one thing. You can't lie and say you killed Donovan Thomas, because if you say you killed Donovan Thomas, then you're going to mess up my case, because I want people in the jury to think that Young Thug and his team killed Donovan Thomas, not you. So she said, if you do say you killed Donovan Thomas on the stand, that's the one thing I will prosecute you for. So you can lie only if you lie for me. But if you lie against me, now I'm going to lock you up. And guess what? Your immunity does not cover false statements and perjury. Shout out again to Michael and Coco in the chat. Thank y'all for stopping in. Definitely appreciate it. I was live earlier today and I didn't expect to go live again, but duty called. And I had to report what was in front of me. I didn't make this up. Somebody asked me, is this real? Somebody asked me, was this real? Somebody said, is it 35 plus show? He said, is this real when I first came on? Yes, sir. And yes, ma'am. It's real. Let's go. So, a fair-minded, impartial person would hold a reasonable perception that Judge Glanville lacks impartiality based upon objective facts set forth in the motion. Yeah, he's not fair. We know he's not fair. But guess what? I'm fair. If I don't care what color this man was, I'm gonna get on you because you trampling over the rights of United States citizens. Not only that, if you do it to one, you might do it to two. Two, you might do it to three. And ain't no telling how many people you've done it to in the past and got away with it. Somebody probably is sitting in prison right now because the same judge then sat his ass in a back room with a prosecutor and had a backroom secret meeting. And that is what most of us attorneys are not okay with. And I say most of us because you got some like DA Love. She don't give a damn. She say lock them up, lock them all up. Be mindful, Texas law and application is night and day in Georgia. I've had a Georgia order that Texas was like WTH. Like what the hell? And then Texas had like 29-page order and Georgia 9. Yeah. That's clear. And it is definitely not lost on me that Georgia and Texas are not identical. Most of the rules of professional conduct and judicial conduct come from the federal rules. So the federal level releases rules, and then most of the states copy those rules. But it don't matter what state you in, no judge is allowed to meet in the back room with the witness to influence the outcome of a case. I mean, that just goes against the very heart of constitutional rights of a fair trial, an impartial trial with a public trial. I mean, that's a Sixth Amendment right. You have a right to a speedy and a public trial. It's not public when you're in a back room with the door closed and the lights off. Allegedly sitting on his lap, DA Love. Hell wrong with you? Oh, man. Say it. I'm going to say it. I'm going to say it. If nobody else say it, I'm going to say it. I got the mind to put myself in the meeting tomorrow. Say, don't disturb me. And we all not gonna have the same opinions, and anybody's free to disagree with me. I'm not gonna penalize you, block you, and all that type of stuff because somebody got a different opinion. Somebody may say it's fair for the judge to be in the back, right? And in any state, this judge needs to be up out of there like more. I'm positive he has done this many times before to the point he was so casual to admit it this time on camera. Yeah, great, Chef Antonio, you're right. He was so casual, he thought it was business as usual. And not only that, he was so offended and shocked that somebody told on him. Like, what? He was so shocked and upset. Somebody went out his office and told that he put the lawyer in jail that called him out on it. I think it's going to be boring the next couple of days. I don't know now. Because you got to remember, Judge Glanville, he vindictive. If you don't do something he say, or you do something he don't like, it's going to be hell tomorrow. Because he's reading this like we reading this tonight. He's at home right now reading this. And he mad as hell. But guess what, Glanville? I can save you the trouble from reading it because I'm over here skimming through it. And we just can touch on the hot button issue. Not the lights off, and the blinds closed. He didn't close the shades. That's a shame. Love is not on his lap aloud, but maybe one of them women. Which one? Nah, Mr. Hilton, I don't think Hilton. Nah. So the people that he has locked up, if the judge gets found guilty, does that mean this people get an appeal? I will say it would be worth looking into, and if the DA's office had, has any uh, remorse, which is hard to say because they was in on it too. They would have a conviction integrity unit look into this. But like I said, the DA's office is the same ones that was in the back room. So we can't depend on them to do the right thing. So it may have to be like the Innocence Project or an independent body look into them. Laugh. I don't know. He just said we'll deal with this tomorrow, but I can imagine he will have to address this first. Right? He really has no choice but to either recuse or stop until a judge can decide. Right. So in the beginning should be fireworks. At the, he gonna come in mad as hell. The best side probably after this bomb completely drops. He at home rubbing the fur off. Yes, he is about to get the. Oh my. Y'all funny. I'm right here in Atlanta and I know the whole DA office needs to get out. Oh, you in Atlanta. So it's a lot of y'all in Atlanta. Who seen that song Welcome to Atlanta? Not the old version. Went in the new version. No, yeah, I know Luda, but it was somebody else after Luda that came out with their own version of Welcome to Atlanta. Jermaine, no, I don't think it was Jermaine Dupri. Man, let me see. Oh, Migos did a version. Migos did a version. But yeah, all of those, Luda and Jermaine Dupri, because when I just looked it up, all of them were in there. New version of the Freak. Somebody says Judge so mad he at home BJ. No. No. No, not Jack. Judge, don't do that to Jack, because we gave you plenty of chances. I even was saying, like, Judge, when you put him in the back, I'm like, go calm down, come back out, cool off. And let me see. Thank y'all to the people that subscribed. I see some new ones popped on. But let's see if we can finish this thing up before Miss Sylvia start her her oh, y'all funny. Y'all are funny. Okay, Benamai. Okay, so Brian's still saying that further, this indictment must be dismissed. A mistrial granted based upon the courts and prosecution's continued misconduct. He said not only were they doing wrong, they continuing to do wrong. They need a fair trial. Judge Glanville, lawyers for the state, Love and Hilton, will be called as witnesses at trial for the jury to understand this secret meeting and determine demeanor and credibility. Additionally, Jeffrey Williams, Young Thug, demands all secret meetings to be disclosed. Not tomorrow, not the day after, on Juneteenth, not the day after that. He said immediately, instantly, in order to properly reveal the full extent of all the violations of law and ethics. So what the defense is saying, when it's their turn to present their case, they are going to call DA Love and DA Hilton to the stand as witnesses. Now that's going to be something right there. Who does the defense call next as your witness? District Attorney Adrian Love. The jury going to be like, what? And obviously you cannot be a witness and a lawyer on the case. So if that happens, she would be disqualified. So I'm sure that they're going to fight that. And then DA Hilton. DA Hilton, did you really, on record with the court reporter, tell that man that he can lie under oath? And you are a professor at a university. Have you lost your damn mind? Have you lost your everlasting mind? To tell that man, and the court reporter is typing everything you say, that he can lie under oath about one thing, but he bet not lie under oath about another thing. Thank you, Coker, for that. He said that he at home punching the air. So they said, we're going to call you as a witness. We'll be called as witnesses. We don't give a damn if you like it or not. Okay. Again, lawyers for the state, Love and Hilton and Judge Glanville are necessary. Oh, now they're calling the damn judge as a witness. And Judge Glanville are necessary witnesses at this hearing and trial to determine the correctness of this motion for mistrial, goaded by the conduct of these parties / judge. You ain't got to say party / judge. They all on the same team now. I think she did. I think she absolutely did, because we got to remember, it was also reported by Miss Sylvia. You know, she's in the courtroom every day. She reported that. She seen her with her own eyes. She seen Miss Hilton crying after this revelation was revealed. And you got to remember, she never jumped up when Steele said all these things. She didn't jump up and run to the mic and said, I never said that. You know, I'm going to clear my name. I didn't tell him a lie under oath. She sat right there in that seat and didn't say a word. That sounds like an adopted admission to me. If you sit there and somebody's saying you did something and you don't correct the record and you just let it go with the flow, that means you are adopting what they're saying as truth. Wherefore, let's go to this. She must have forgot something. I hope she's making enough at that college. I don't think you got to have an active license to practice law. But, and she got to remember, see, the bar, she might get away with certain stuff in Fulton County because of her boss. Her boss controls a lot of the prosecutions, but your boss don't control the state. And we all know the state is not in favor of that county at the moment, especially with the prosecution of Trump going on. We know the Georgia legislature is mainly Republican, and then, you know, obviously Trump might be president again. So the legislature is not going to be happy with that county, and they're looking for a reason to go in and shake some stuff up. Somebody said, baby. She left very soon after that meeting was over. She only came back because the judge told her she had to. Oh, Miss Sylvia right there, she can see and hear firsthand. So she was crying after they raised that. Yes. Okay, let's see. I'm finna share my screen. Let's see if we can get Miss Sylvia. And this is obviously being shared under fair use. She crying because she knows she on record breaking the law. Oh. Okay, let me do that. Present, share screen.
File, and everyone is like in uproar about it and things like that, right? But I have something myself that I wanted to show you guys, which is exclusive. No one else has this, but I wanted to bring it out to you guys' attention. This hit on Friday night when no one else had. No, I sat in the cut waiting to see who's going to bring it out and seeing if anybody was going to say something, and nobody said anything, right? So I decided to bring it to you guys' attention. Well, Friday at about 10:49 p.m., Miss Kayla Bumpus decided she wanted to speak up for herself, and she filed a motion. And her motion she filed is basically to have the judge to quash her thing for her to do that hearing, and also for him to recuse himself. Okay, she started that. Okay, so without further ado, we're gonna go ahead and put my little thing up so you guys can read it. All right, this is my little emblem here. Okay, here we go.
Oh, she filed a motion.
I'm gonna get my butt out the way so you guys can see it, and let's go. Hey, Quinetta. All right. She lawyered up. Here we go. You guys see this?
Thank you, Michael.
Let me share it first. Hold on.
I hope she lawyered up, because the judge trying to put her in jail now.
Here we go.
Thank you, Tamika.
You guys see this? It says
barely.
Georgia, whatever, blah, 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 blah. And it was filed, you see, at 10:40 p.m. on Friday. This is when it was submitted. It says motion to quash, order to show cause, and motion to recuse this court. Now comes Attorney Kayla Bumpus through undersigned counsel and files this motion to quash the court's order to show cause filed on 11/20/24. Or in the alternative, move this court to transfer this action to another judge or recuse itself as required by law. In support thereof, Attorney Bumpus shows the following. Y'all ready?
Yeah, I mean, that's her screen. Maybe somebody will tell her. She got to zoom in.
Recitation of the facts. On Friday, June 7, 2024, during the trial, the state immunized Kenneth Copeland and called him as a witness. Thank you. There's a way. Somebody help her to become a member on the iPhone, please. Help her to become a member on the iPhone. Thank you, child. Okay. Copeland refused to testify. The court placed Copeland in custody over the weekend for his refusal and adjourned until Monday. At this point, Copeland was still sworn as a witness and had not been dismissed. On Monday, June 10th at 8:30 a.m., Copeland and his lawyer, Attorney Kayla Bumpus, were escorted to this court's chambers and conducted an ex parte meeting regarding Copeland whether Copeland would testify. Those present for the substantive portion of of this ex parte meeting were, now here's everybody that was there, y'all. Here's everybody that was there.
Okay.
Chief Judge Glanville, Copeland, Attorney Bumpus, Assistant District Attorney Adrian Love, and Simone Hilton, a member of the court security staff, and deputies, 2 investigators from the district attorney's office, and a court reporter. In chambers, this court asked Copeland whether he was prepared to testify. Copeland announced that he planned again to invoke his Fifth Amendment privilege on the stand. A conversation among the party ensued regarding Copeland's understanding of immunity, how Copeland thought he may testify if he did not invoke the Fifth, and certain facts of the case. Once Copeland learned that he could be held indefinitely by the court if he refused to testify, not just 2 years as he initially believed, Copeland decided that he would testify. Copeland added that his testimony would be a lie. You hear this? Copeland added that his testimony would be a lie. The meeting ended and the parties went to the courtroom. This ex parte meeting was not placed under seal. There was no protective order that directed that disclosure of this ex parte communication was prohibited. No attorney-client privilege existed. Clearly, as 2 prosecutors, investigators, a judge, and a court reporter, and various court staff were also all present.
Right.
The court never stated, ruled, or inferred that the meeting was meant to be confidential. Okay? Further, the content of this meeting was not secret, protected, or any way privileged information. It is unclear why any person present would have understood that the content of the meeting could not be shared with other attorneys on record in the case who are also with fellow officers of the court. Okay?
She the mo? She admitting it was her?
Later, the same day, defendant counsel attorney Brian Steele addressed this court to make a record of his due process concerning the ex parte meeting. The content of said meeting would not just be non-confidential, but would usually be given to the defense under Giglio and Brady. During attorney Steele's attempt to put his due process concern on record, this court began to focus on the identity of the source who leaked the meeting to defense counsel. The court ordered Steele to provide the name of the person who divulged the existence and content of the ex parte meeting. Attorney Steele refused. A brief hearing followed, and what initially appeared to be a classic civil contempt action, the attorney could purge himself of contempt if he provided the information to the judge, became a criminal contempt action. The court found attorney Steele in direct criminal contempt. This court sentenced Steele to the maximum time allowed, which is 20 days to serve in the Fulton County Jail. On June 11th, this court, 2024, this court entered a show cause order directing all individuals that were present for the ex parte conversation to take place in the court's chamber on the morning of June 10th, 2024. Specifically, Copeland, his attorney, Attorney Bumpus, and all representatives of the state and county security personnel that were in attendance to show cause. Why One or more of them should not be held in contempt for disclosing information from the ex parte conversation to members of the defense counsel. No specific name were included in the order other than Copeland and Attorney Bumpus. Okay. Y'all heard that, right? Here's the argument. The court seeks to hold a contempt the person that leaked the ex parte meeting to the defense counsel. Thus, the contempt hearing will be about who informed defense counsel whether to find that person guilty of criminal contempt, and if contempt is found, the appropriate punishment. The procedure that a trial court must follow to hold a person in contempt depends upon whether the acts alleged constitute the contempt were committed in court, direct contempt, or committed out of court, indirect contempt. All right, here we go. Kayla, you in here?
Okay.
She in here?
Kayla, where you at? Where you at?
Kayla in here.
Let's go. Bring her up. Bring her up.
Okay, I thought she was in here. Okay, I thought somebody mentioned her. Okay. An alleged serious, I don't know how to say that word, okay? Don't talk about me. Act may only be said to have occurred in the presence of the court, warranting summary contempt proceedings. If the act was committed in open court, on the other hand, where the alleged I don't know how to say that word, contumacious act are committed outside the court's presence, the consideration justifying expedited procedure do not pertain. Thus, summary adjunction and indirect contempt is prohibited, and due process requires that a person who is tried in indirect criminal contempt is entitled to more normal adversity procedure. Among other things, he or she must be advised of charges, have a reasonable opportunity to respond to them, and be permitted the assistance of counsel and the right to call witnesses. C. Adams, and then they give a case number in that, emphasis original. The disclosing information from an ex parte conversation to members of defense counsels occurred not in open court or in chambers, but at the time and location that the defense counsel were notified of the ex parte meeting. Further, direct contempt involves contemptuous conduct in the presence of the court, which generally results in immediate punishment. Here, the need for punishment is clearly not immediate, as demonstrated by the show cause order being set 2 weeks out from the order. Forms of contempt are further divided into criminal and civil. Based on the nature of the punishment imposed, civil contempt is conditional punishment intended to coerce. Hold on. Go to the next one. Hold on. Okay, hold on. I got the go down. Coerce the competor to comply with the court's order, Hopkins versus Hopkins, and then the case number on that. By contrast, criminal contempt imposes unconditional punishment for prior contempt to preserve the court's authority and to punish disobedience of its order. And it gives a case number on that one. Contempt alleged by this court of disclosing information from an ex parte conversation to members of the defense counsel could only be criminal contempt. Nothing could be done to purge or undo the alleged contemporaneous action, and any punishment would amount to criminal contempt. A, no contemporaneous conduct occurred. There neither is nor was any preventing the disclosure of this ex parte meeting to defense counsel. Disclosure did not violate a court order. There is no standing order in place or trial order that bars or any way limit defense counsel for witnesses or any other individual present at the ex parte meeting from communicating with the defense counsel for the defendants about the meeting and its content. Okay, and it gives a case with the protective order stuff. Okay. All right. Next one. It says here, to the extent that this show cause order may be subject to a general demomer, the order cannot pass this test, assuming as the true the allegation of disclosure information from the ex parte conversation to members of the defense counsel. Contemporaneous conduct is not alleged. Furthermore, contempt may be found only where the attorney knows or reasonably should be aware in view of all the circumstances, especially the heat of conversation. No, controversy, that he is exceeding the utmost limits in his proper role and hindering rather than facilitating the search for truth. And this is a case number here, too. Hold on, I gotta go down. All right. In Jefferson, to give a case number here, disclosure of the meeting did not exceed the limits of any one proper role, or if anything, the disclosure facilitated the search for the truth. A judge may reasonably expect his clerk or other judges to keep what happens in the chamber professionally private. However, they are under no legal duty to do so. Such an expectation of privacy does not extend to third party, not part of the court staff. Holding an ex parte meeting in chamber did not impose a duty of secrecy. Informing counsel of defense of the existence and content of this chamber meeting did not violate any rule of law, trial order, or standing order, and is not a basis for contempt. The show cause order, failing to articulate an act of contempt, should be quashed. B, this court must transfer this contempt matter to another judge under the procedure for indirect contempt, or alternatively recuse itself pursuant to Georgia Code of Judicial Conduct Rule 2.11. This court must transfer this matter to another judge under the procedure for indirect contempt. The court may not preside over this contempt proceeding because the court does not satisfy the following criteria. Indirect contempt action, the trial judge who was presiding over the trial during which the alleged contemporaneous conduct occurred may preside over the contempt hearing. If the contemptuous conduct was not direct towards the judge and the judge did not react to the contemptuous conduct in such manner as to become involved in the controversy. All right, let's go to the next one. Here, the alleged contemptuous conduct was expressed by the court, directed at least in part towards the court's personal and sacrosanct nature. sacrosanct nature of its chamber. The court became involved in the controversy both by holding the ex parte meeting in the first place and by the way of the fact that this court is a witness to the potentially dispute fact of whether there was any kind of order to disclose the meeting to counsel for the defense. The Georgia Code of Judicial Conduct court dictate recusal because the court's impartiality might reasonably be questioned. When considering the issue of recusal, both OCGA 15-1-8 and Canon 3 of the Code of Judicial Conduct should be applied. The Code of Judicial Conduct provides a broader rule of disqualification than does OCGA 15-1-8, Jones County versus a mining group, and it gives a case number on that. The broad rule of disqualification set forth in Georgia Code of Judicial Conduct, Rule 211, formerly 3.9, provides judge shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned, in which the judge has a personal bias and prejudice concerning a party or party's lawyer, or personal knowledge of dispute evidentiary fact concerning the imminent matter or the pending procedure. Here, the court impartiality might reasonably be questioned for 5 reasons. First, this court stated this is a sacrosanct to have the conversation in my chamber, parroted to you and others. It is that serious, revealing that the court views the harm to be at least in part a direct harm to this court personally and or the sanction of his own chamber. Second, as described in the case called show cause order, some of the other participants in the ex parte hearing were the court's own security personnel. This gives rise to 2 issues.
I think she almost done, y'all.
Potential witnesses may be testifying at the hearing, at which time the presiding judge will have to access to the credibility of their testimony. It might reasonably be questioned that this court would give more credibility to the court's own security personnel than it would other potential witnesses, such as attorney bumpers. Further, the court own security personnel and reporter, like attorney bumpers, are subject to potentially be held in contempt.
Y'all funny.
This court is impartially might reasonably be questioned. If it were to sit as both prosecutor and fact finder, where deciding if it was the court's own security personnel and reporter, someone else who disclosed the meeting. Third, this court has personal knowledge of a potentially disputed evidentiary fact of whether there was an order of any kind barring disclosure of the meeting to counsel for the defense. Fourth, this court appeared to already have decided prior to any hearing that it was attorney Bumpus who made disclosure. So she's being accused of doing that. It says the judge already made a decision it was her. Okay, it says it was attorney Bumpus who made the disclosure. While holding attorney Steele in contempt at the court stated, well, they're other than you, attorney Steele. if you were sitting, unless you were sitting there with a recorder, or Miss Love, or Miss Hilton, or one of the deputies gave you the information, or Miss Weaver shot you a rough copy of the transcript. There's only one other person that's left. And if that person gave you the information or shared the information with you, she probably violated privilege.
Here we go.
I should have did the judge's voice. This court show cause reinforces this predetermination as the order referenced no other person present at the meeting by name other than Attorney Bumpus or Copeland.
Oh, yeah.
Fifth and finally, the court was visibly impacted when it learned that Attorney Steele had been informed of the meeting. The Georgia Supreme Court referred an opinion echoing this case is noting when a recusal motion clearly has merit.
Oh my God.
But what if the motion to recuse has merit? What if the judge who announced an oral ruling is or reasonably appear to be partially or prejudiced? Uh-oh. Hold on, let me go down.
Come on.
Uh-oh.
There we go.
Partially and prejudiced, and therefore has no business continuing to preside over the case. See Georgia Codes of Judicial Conduct, Rule 211A1. What if an example of a party defending himself at contempt hearing turns around and accuses the judge of prejudice, and the judge actively defends himself and then orally holds the accusing party in contempt? Gave a case law on that. Explaining that argument over recusal issue may draw the judge into presiding his side of the story, which in turn creates a perception that the judge is an advocate or hostile witness rather than an impartial adjudicator in the case requiring disqualification. And give a case law on that one.
Y'all are fun.
This alleged contempt is not ongoing and does not require immediate resolution. This court has ample time to transfer this case to another judge who was not involved in the ex parte.
Hey, is it me or do y'all think Kayla and Brian Steele wrote their motions together? Because they sound exactly alike. And I'm going to speed up Miss Sylvia a little bit.
Seating a direct personally and
Okay.
or the sanctity of the judge's own chamber, who is not called to determine whether the court's own security personnel or reporter committed an alleged contempt, and if so, what punishment to impose. Oh, hold on, y'all. I got a call coming. Hold on.
Oh, not a. Hold up.
Hello.
Oh, we're going to listen to
I'm live now.
Oh, come on.
Okay. Sorry, guys. Sorry.
Is that Kayla calling
He
you?
was asking me what time was I going live.
Oh.
Okay, we're at the middle part here. This alleged contempt is not ongoing and does not require immediate resolution. This court has ample time to transfer this case to another judge who was not involved in the ex parte proceeding, who is not a potential witness to a potentially disputed evidentiary fact, who does not view the harm to be at least in part a direct harm. Hold on.
Take your time. You know, somebody yell out to the pastor, take your time, pastor. Oh, another call.
Huh? I know. What?
You got a boy over there showing your live on his channel. He got permission to do that? This just fair use. We just going through the motion.
Sorry, guys. Everybody's calling me now. What? They want to see if I was reading it. Hold on.
If you was reading it,
I just lost my spot.
Oh, don't go back. Don't go back to that first page. Don't you do it.
Where am I at, y'all?
The last page.
Where am I at?
Somebody type in her chat the last page.
1671, 1671, 1671, 1670. Okay, I see where I'm at. Okay. All right, here we go. 1671. Okay.
Oh, she's in the chat. What is she saying?
I don't want to read the same thing over again. Okay. The reporter committed an alleged.
Hey, can y'all copy and paste Kayla's chats over here so we can see what the hell she's saying?
Contempt. If so, what punishment to impose?
And I wonder if Miss Sylvia going to bring her up after she get through reading all this carrying on, as they say.
Is criminal. A full penalty of constitutional protection must be afforded the accused, and it gives a case law on that. This include a notice fairly and fully inform the accused of specific act of contempt. This requirement is reasonable notice in a case involving an alleged indirect contempt. To contemplate the necessity, a written notice fairly and fully inform the accused of the specific act of contempt with which she is charged, and so given on as to afford reasonable time to make her defense. Any notice short of that would make a hollow mockery of the fundamental and abiding truth that reasonably notice to one whose civil rights or personal liberty may be affected in a veritable cornerstone of our judicial system would constitute nothing more than an exquisite exercise in frustrating futility, sometime misleading and always meaningless, and would be sounding brass and tinkling cymbal, a notice in form, by not in substance. Okay, there's a case law on that one. Which, like all crimes, contempt has an act requirement and a mental component, mens rea, actus reus. In Jefferson case law in that cited citation omitted, the notice alleged an actus reus disclosing an ex parte meeting, but fails to put attorney bumpers on notice of the mens res, that or how the disclosure would know such an act amount to contempt. The notice does not allege facts from which a contemporaneous mens res would be inferred. As set forth above, the act of disclosing the meeting to defense counsel cannot in and of itself amount to contempt. The disclosure could not only potentially amount to contempt, it is violated a court order or other legal duties to not disclose an ex parte meeting. The notice failed to allege any such restriction. As such, the notice failed to fairly and fully inform the accused of the specific act of contempt. Wherefore, Attorney Bumpers moves this court to 1. Quash its order to show cause, or in the alternative, 2. To recuse itself from proceeding and or transfer this proceeding to another judge whose impartiality can't reasonably be questioned. Or in the alternative, let's see, 73.
Shout out to Sylvia.
3. Provide an adequate notice that full and fairly inform Attorney Bumpers of alleged contempt. That was 3, sorry. 4. Should all the above requests relief be denied, Attorney Bumpers request a certificate of immediate review. Submitted the 14th day of June, 2024. And you have Julius Collins.
Ooh, we got to the end.
Okay, Julius Collins, and you
I
have
will,
Christine Nova.
Tiff, thank you for
You have J.A. Garland. You have
thank you, Tiff.
Matthew K. Winchester.
I love Miss Sylvia.
You have Nicole Mormon.
That's true. She the only one with that
all
document.
Of these attorneys in here. Go
I swear I won't ask for it.
Attorneys for Caleb Bumpers. Oh my God. You got Gabe Banks too? Oh Lord. She got the A team.
She got who? Who she got?
Okay, here we go. It is a certificate of service. Okay. She got the A team. This is the show cause letter from the judge.
Thank you, Tiff.
And this is the affidavit support the motion to recuse the judge. Okay, let's see what she says. Let's see what they say on this one. Let's see what they say. All right, number one, Chief.
From my understanding, what people are saying that this was filed under seal, so we don't know how the hell Miss Sylvia got it. I don't even think none of the other places got it neither.
Judge Glanville is presiding over the above style case. 2. Sworn witness Kenneth Copeland was held in civil contempt of court on June 7th, 2024 for refusing to testify after being given a grant of immunity by Chief Judge Glanville. 3. On June 7, 2024, Chief Judge Glanville informed Mr. Copeland and all parties that Mr. Copeland would be jailed and brought back to court on June 10th, 2024 at 8:30 a.m. 4. On the morning of June 10th, 2024, an ex parte meeting was held in Chief Judge Glanville chamber. That ex parte meeting included Chief Judge Glanville, Mr. Kenneth.
So this is a motion filed by Woody's substitute lawyer, Kayla Bumpus. She wants her contempt hearing to be canceled or quashed, as they say in the court of law.
Copeland, his attorney, Ms. Kayla Bumpus, and representative of the state and court security personnel.
Thank you, Yvette.
Number 5, later in the day of June 10th, 2024,
thank you,
Mr. Steele, counsel for Mr. William, informed Chief Judge Glanville that he and others had learned that of the ex parte meeting. The court acknowledged that the ex parte meeting had occurred.
Oh my
6,
God.
Mr. Steele requested information about the ex parte meeting, which Judge Glanville did not provide. 7, Mr. Steele made a motion for a mistrial asserting that the ex parte meeting violated Mr. Williams' constitutional and statutory right, including the right to due process and a fair trial. Chief Glanville denied Mr. Steele's motion. Number 8, Chief Judge Glanville repeatedly ordered Mr. Steele to provide the name of the person who divulged the existence and content of the ex parte meeting. Mr. Steele cited State of Georgia Bar Rule 1.6, confidentiality of information, declined to provide the information requested by Chief Judge Glanville. Number 9, Chief Judge Glanville held Mr. Steele in contempt for refusing to provide the name of the person that divulged the existence and content of the ex parte meeting. 10, the next day on June 11, 2024, Chief Judge Glanville entered a show cause order directing all individuals that were present for the ex parte conversation that took place in the court's chamber on the morning of June 10, 2024, to include Mr. Kenneth Copeland, his attorney, Ms. Kayla Bumpus, and all representatives of the state and court security personnel that were in attendance to show cause why one or more of them should be held in contempt for disclosing information from the ex parte conversation to members of the defense counsel. 11, the order to show cause only referenced Ms. Bumpus and Mr. Copeland by name. All the other in attendance, despite having access to the same information, were not named in the order. Upon learning that Mr. Steele was aware of the ex parte meeting, Chief Glanville stated this is a sacrosanct, y'all know what that word is, to have the conversation in my chambers parroted to you and others it is that serious. 13. During this exchange, Mr. Steele on June 10th, regarding the ex parte meeting, Chief Glanville stated.
What did he say?
Hold on, let's go down.
What did he say?
He stated, then other than if you were sitting, unless you were sitting in there with a recorder, or Miss Love or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there is only one other person that's left. And if that person gave you that information or shared the information with you, she probably violated privilege because she has a client she's supposed to represent. 14. And that Judge Chief Glanville was referring to in that statement, paragraph 13, was Attorney Bumpus. 15. Chief Judge Glanville made the statement referring to paragraph 13 before he made any inquiry of any factual determination. Chief Judge Glanville has already determined that it was Attorney Bumpus that leaked the information to Mr. Steele, and that determination was made prior to any hearing and based on his own knowledge and belief. 16. Chief Judge Glanville accused Attorney Bumpus of violating attorney-client privilege when speaking with Mr. Steele, and made such said accusation prior to any investigation, hearing, or reviewing any evidence. 17. Chief Judge Glanville intends to preside over the June 11, 2024 show order to show cause in the same above style case, and he will be the fact finder and make credibility determination certain concerning the parties present at the ex parte meeting. 18. If Chief Judge Glanville were to preside over the show cause hearing, he will have to make credibility determination of the court's own security personnel. Further, affair said not. And then Julius B. Collins and Christian W. Nove. All right, y'all. All right.
Good job.
We got this.
We made it. Let's see if Kayla go up.
That is the end. All right. So, guys, y'all heard it. Y'all heard what happened. This is there's some stuff, isn't it, guys? It's some stuff. It is some stuff. So, what do you think is going to happen, y'all? Something to tell y'all, but I don't know if I could tell y'all.
Tell us.
I don't know if I could tell y'all.
You here now?
I got something to tell you, but I can't. I don't know if I could tell y'all.
Come on.
Because you know me.
What?
Let me turn on my light. Hold on.
Oh, come on.
Let me turn on my light.
Let her get a light on, y'all.
You know me, y'all.
Whew.
You know me. I hear things. All right, let me drop the link. Y'all.
Oh, we got a link?
Oh, Kayla
finna come. Kayla finna come. Wait.
Hold on.
Tips tape. We heard it, but we don't know what it said. And thank you.
You didn't hear from me.
For the cash.
You didn't hear from me, but let me tell you.
Thank you for the cash tip. Let me see.
I ain't hear it from me.
Need to turn on the closed caption.
I ain't gonna tell you. I ain't gonna tell you.
You know what?
I ain't gonna tell you.
Woman.
Nope, I'm not gonna tell you. Cause somebody come on up here. I ain't gonna tell y'all. I ain't gonna tell y'all. I'm gonna let y'all find it on your own. I ain't gonna tell you. All right, here's the link. Go ahead on.
Well, so okay.
I heard it today, y'all. My ears was like this.
What you?
Okay, D.
Good, tell us.
D, your thing is not working. Your thing is not allowing you to come on. D was trying to come on up here, but okay, AJ. Hey, AJ.
What's going on? What's going on?
Nothing. How you doing?
Man. How y'all doing?
What do you think gonna happen?
I think this case is going to be over sooner than everybody expects it.
I predicted that.
You did, and you said it first.
I said it first.
You did. You said it first. Given the latest developments and how it has been playing out, I said in the chat, what's done in the dark will come to the light. What's up, Blink? And it's all because of the state in Europe. They the ones that caused this. They've been playing this way. They decided to play this way, and Steele has been sitting back, taking notes, taking his licks, so to speak, from Europe, and he's done playing. He's been the most professional and prepared person in the room every day since November, and it shows.
Mm.
And it's not even opinions. This is all facts. What you just read.
Yeah, it's facts.
I can't leave.
So there's no way
I'm gonna leave
that
here.
you can't get around this. Euro can deny it, which he probably will, but it's gonna go above his head and beyond his control. And I can tell now, in hindsight, looking back at the way Hilton's body language has been, she ain't been wanting this. And it makes me think why Love has not been on the record for 2 weeks now.
Yeah.
So it's like you put the puzzle together. But yeah, I don't think that this is going to go to duration, especially not the 25 anymore, given the latest developments. And it's from lack of evidence, man. It's like the defense didn't even have to get to presenting their case yet, and they've already won, basically.
Click
to
the
me,
link.
in my opinion.
Yep,
So,
you're right.
So here we are, and it's all because of the state in Europe. Nothing that Steele forced them to do or he was doing. It's all been on them. They've been the ones talking and not allowing everything.
Yeah, I don't mind going over there, but I don't know how that will work. If I was to leave here, will it still stream here? If I was to go over there, I'm not sure about the technical side, or would they be like I don't even know, like an echo? I've never done it before. Hey, but let's see.
Everything that happened.
Let me
the
speed it
proper
up so
way.
we can see where we at. Let me speed it up.
So it's a lot, right? Did y'all get a chance to hear Steele's motion?
I did read Steele's motion.
No.
His motion is very detailed and his strong worded. And I mean, like I said, that's why I say that he's done playing, man. He's done sitting back, watching, trying to let the process take its course. And the way Euro talks is if it's already done. Well, you could just do it in appeals. You know what I mean? It's like he's already made up his mind the way he says stuff.
Is he seem biased?
Yes, very. He's been like that for the jump to me because of how he treats them. When he cuts them off, he doesn't. Okay, when they get to arguing, he always makes the defense present case law, but he just let Love just chat away, and then he argues for them.
Yeah. Hey, Xavier, could you show your face, please? Because you have no picture there. And can you show your face? You don't have to show it to everybody else. Just show it to me right now.
Oh snap! You can see.
I can see y'all when y'all first come in without putting you up.
Oh my God! I'm sorry.
Okay, Xavier, could you show your face, please?
You're not supposed to be seeing all that. I'll just play.
What
Xavier, could you please show your face?
And also with the way Steele worded his, it's like he's pushing for a mistrial without retry. Like no double jeopardy. Like it's over with. It ain't gonna be no trying another crack at the thing again.
Yeah. Okay, Xavier's not listening to me because he decided to leave. He didn't want to show his face. Okay, Mr. 444 smile. Can you show your face, sir? I want to make sure it's you. Oh, there goes Xavier. Okay, Xavier, I see you. There we go. Hey, Xavier.
Hey. Hey, can you hear me?
I can hear you. Can you hear me?
Yeah. So
y'all want to stay? What y'all want
to? If it goes to a mistrial, what do you think?
Y'all want to keep watching? What y'all want to do? Let me know.
Happens. Do you think the state has enough funds to be able to run this case back?
I was told because you know me, I would go around asking questions and stuff. I was told that this right now has cost them so much money. They doubt there will be a retrial.
That's what I thought too. Just because I mean the numbers that are floating around is like 47 million between the Trump case and the YSL case, and that's a lot of money.
Remember, they had overtime. They was paying everybody transportation. You had food, everything. You could name it. They was even paper. The price of the paper, printing, and all that was high.
And I don't understand is, I mean, I never had to serve jury, but I mean, how do you pay somebody $25 to do your job? I mean, at the end of the day, the juries are the ones that are doing all the work. Yeah, the state and the defense has to get up and present it, but I mean, the jury's the one that are having to do all the homework at the end to come back with the verdict, but to get $25.
Xavier, let me just tell you, the faces they had today, they like one of them was not even watching the video, wasn't even paying attention. I'm like, they really just like over this case.
And I would.
Well, I think it's because one, the audio, you can hear it, but you can't hear it. And
yeah,
I mean, I almost fell asleep just watching it sitting at my house. I'm just like, yo, this is boring. I'm ready to go to sleep.
Yeah. Yeah. What y'all thinking? Say what now? Right. I was trying to see because I thought she was going to say something else. Y'all think she's going to share whatever she's holding out on? She's saying that she heard something, and I was trying to give her a little bit more time. Let me see. Let me fast.
You can imagine.
You haven't shown me anything that says that that Young Thug is the leader. Young Thug has made these guys do it. Young Thug has paid any of them to do it, and that's what they're saying. And if you go back, they have already put on screen, and maybe on their big old whiteboard that she writes down on, that there's somebody, one or two people that are ahead of Young Thug on their little diagram that they have. Mm-hmm. So Young Thug's not even the top guy on their pyramid.
Yeah. They really made Woody mad today, y'all. He was pissed.
What was that? I believe was that after his request to see the defense?
That was before he asked to see the defense.
I wonder what that conversation was. I'm pretty sure it was filled with truths, but
well, he didn't. He was at. I mean, when I tell you he was going in. He told one of them, "Don't touch me. Get the F away from me." Ooh. He was going in.
He told one of who that? The
investigator. Remember the lady that you see her face on my thing? So yeah, everybody was asking me, who is she? The lady who sits there and she's like closest to me. Well, she's like the investigator that's with the witnesses when they come in and out and things like that. She'd be in the back room with them. And he told her she got ready, You know how somebody always like touch them to go walk out the door, and well, he was like, "Get the F, don't touch me, get the F away from me."
Yep, Todd Glass. I'm pretty sure they told him that they wouldn't show the video, but you know that's what the state do. They gonna lie to you.
Well, they
That's why his what's his name? His original attorney told him, just plead the fifth, bro. But they didn't want that. Like Steele said in his affidavit, even after being told I'm not testifying and pleading the fifth, they still was bullying him.
Mm-hmm.
Judge ignored it. Well, I'm sorry, Euro ignored it.
yeah.
Hey, so who else noticed in those interrogation videos that they've shown so far? You know, I mean, not the ones that everybody else has leaked. The ones that they've shown today, they anytime anytime Young Thug was brought up, Woody would either deter him away from it or wouldn't make it to what the case is supposed to be. It went the opposite way on that. Even in 2015,
him.
even in 2015, if you remember, Woody said in that interview that, I mean, when he was running with ABG or whoever the hell he was running with, he got out after 2015, and that's when he started messing with YSL, and he released the gang stuff. He didn't want no more part in it, and that's why he was with YSL, because they were into the music. So he never even said that YSL was a gang. He hasn't said that YSL is a gang. He said that he's been with
Hold on a second, Xavier. I mean, my honored guest here. Kayla, how are you?
Oh, Kayla here. Kayla here, y'all.
Can y'all see me?
Nope. Cut the camera on.
No, it's dark.
Oh, she here. Let's go.
But how do I fix it? Because everybody thinks it's not really me.
It's not you.
Yeah, I know it's you. I know your voice.
We can see you.
We believe.
Let's go.
I don't know how you fix it.
Let's go.
I don't know how to
at the very bottom is where your camera's at, where you turn it off and on. That's why when you kept telling me to show my face, I was trying to figure it out too. I couldn't figure it, but it's at the bottom, so I had to back out to get it to come back on.
Let's go.
So
turn your camera on.
Kick all the other people out.
Turn her camera on.
Well, it looked like her camera's on. If her camera's not on, it'll show like either a no profile or like mine does an X.
That was her, y'all, because I know her voice. That was Kayla.
Okay, bring her
there
back.
There she go. See, now it's showing her camera. Her camera is not on. It showed a picture a minute ago. Tell her to go out and come back in, but then when she come back in, make sure that the camera light is not has an X over it.
Let's go.
When she come back in, she should see her picture first and then hit send to come in.
Okay, y'all. Everybody's gonna have to mute when she comes up because I want her to talk. Okay, guys. When she comes up.
Definitely.
That's what we're talking about. Now who bumped off?
Let me put the link back in. Rand, can you put the link back in again for Kayla?
Let's go, Kayla.
And can I say something real quick?
All right, so we can see her picture.
Go ahead, Saucy.
I feel like the defense was tired of the bull crap, and they sent an ex-prosecutor in there because they felt like it was going to be some foolishness. They basically have seen all along that the defense, the prosecution team has been playing dirty all this time and still never want to play dirty. But finally, he just said, okay, y'all want to be slick, put that ex-prosecutor in there. They thought that it was going to be like, okay, yeah, she on our team. That's why they did that communication.
Take down for a minute because I'm bringing Kayla up. Okay, guys?
Okay.
Yeah, take them all down. There you go.
There you go.
There you go, Kayla. Shout out to Kayla. Woo.
Hey, y'all.
Hey, there you go.
Let's get into this tea.
Well, you have the floor, Kayla.
Put myself on the panel.
I don't have nothing to say, but hey.
You better say more than that.
So I read the motion that your attorney put in for you. So can you say anything to us?
No, he's already mad at me. He's telling me to get off.
Shout out to Kayla.
Y'all, you see, it is her. We are not going to have her incriminate herself, so we're just going to put everybody else back up here.
And she's just going to sit there.
Are you? Can I ask her a question?
No.
She may not be able to answer you, but go ahead and ask.
Are you an ex-prosecutor from the
yes.
Fannie Willis department?
Yes.
No.
From the previous administration, not Fannie
That was
Willis.
under Paul Howard.
Paul Howard. Okay.
He worked for Fannie.
Before Fannie. Yeah.
Oh, okay. Thank you.
Oh, I get to hold on.
So are you back home now? Did you go home?
I'm home.
Okay.
I'm home.
Yeah, she worked
hit the
before.
wrong button again.
She done knocked her off. Oh, there she go.
Oh, y'all, I'm still here.
Oh my God, this is wild.
I just wanted y'all to know it's me.
It is her. It's not a fake. It's not a Memorex.
How many Kayla's up there?
So I
She done took it down again.
She's gone. Okay, go ahead on 444.
Yeah, see, so Kayla, she worked with DA Love before Fannie got there. She was already there. So DA Love and Bumpers know each other before Fannie was elected.
I think it was you that was about to say something.
Sylvia, let me ask you a question. How you feel this trial is going, and what do you think about today?
Oh, I told you how I feel this trial is going.
Oh.
I told you a long time ago. I told you that basically that the jurors have already checked out.
Put Kayla back
It's
up
a
there.
mess. It's a mess. It's a mess. And all the witnesses that the state have brought up, I'm saying other than the police and stuff like that, they all did not bring what they thought they were going to get from their witness. So not one of them showed up anything.
Do you believe that this case is going to be reached? If it do make it to trial, do you believe there's going to be a hung jury?
Oh, it's going to be a not guilty or hung jury. It's not going to be a guilty. No. Not the way I've seen these jurors. I'm just giving you my opinion. My opinion. That's it.
Shout out to
because
Kayla.
they're overshadowing them with so much evidence and so much discovery to take back here. It's going to be so overwhelming with the deliberation that I don't think that they could deliberate in so much time to be able to come up with a verdict and all that stuff they got to read through.
Yeah. Right.
Hey, Sylvia. Question.
Yeah.
Are you gonna read the motion that came out?
Oh, please. No.
But still, yeah. I just read I read Kayla's and I thought everybody already read it, but
we all read it.
Sylvia, the chat.
I emailed you.
Oh, my bad.
Yeah.
Go ahead.
If she started reading another motion, we gotta let her go.
The chat was asking if Melnick was coming back.
Melnick on a permanent vacation.
No.
And I feel that's because they did what they were supposed to do. They got it set up just right. The prosecutors, they've been playing dirty all this time. Now still play dirty right back, and they bit the bait.
No, see, the motion, we already went over that motion kind of earlier today. It's 27 pages. This is Brian's motion, the one I was just reading. So yeah, that'll be double. I don't think we can take another dose.
Not saying that, it wasn't anything improper done, because when Miss Kayla, Miss Bumpkin came in there, they probably assumed that she was gonna be down.
Did she call her Miss Bumpkin? Or I call her I call her Rumpus. Then Miss Bumpkin.
Wasn't anything improper done, because when Miss Kayla, Miss Bumpkin came in there, they probably assumed that she was gonna be down with the play because she used to work with them. But she wasn't, and she did right by disclosing what happened to his real lawyer, who was, the guy who was out of town. He's supposed to tell him what's happening. That's his client, and I believe that he
You know who else got the motion?
Sylvia, I have a question for you, Sylvia.
Sure.
Exactly what she was supposed to tell him exactly what just happened.
Yeah, because it was, I mean, based on what I read, her attorney put in there, she had a right to it was never told to her not to put anything
You
out.
are
You know,
sick.
I don't get it.
That's sick.
And then my thing is, even if he did tell her, that still, even if the judge said, "Don't say anything," that's what's in this meeting. She still had a right to tell his actual lawyer because she was stepping in for him. So even in that case, she still had to tell him what was said. So for him to think that she did something wrong is crazy, because you got to disclose to the real lawyer what was happening in, with the time that he was gone. And then I'm almost certain he told Steele the second she told him.
Okay, yeah, this is her Cash App. Somebody asked Kayla for her Cash App. This is her Cash App, y'all.
Sylvia, do you think it's a judge's best interest to have a mistrial to recuse himself? Because if he grants a mistrial, you do it all over again and he hides the fact that he has to recuse himself? Or do you think he should recuse himself, or to get out of recusing himself, grant one of these mistrials, and then he could just do it all over again, and then he don't have to be subject to all over again and all that? And then on the mistrial, he can just get a new judge. What you think he should do? Recuse himself or grant a mistrial? What's the best way?
I don't know. I don't know the terminology. Y'all, I'm just covering the case. I don't know any.
All right, so y'all, just to be clear, it was two motions. Brian still filed his motion today, right before court ended, which is the one everyone has. But this motion was filed on Friday by Kayla Bumpers, and only Sylvia has this one. I know the lead attorney had one, but that's the one that came out today. Brian Steele motion, not the one that was read today by Miss Sylvia.
Thing about law, I don't know.
I'm just asking you. I'm asking you what you think. If he recuses himself,
if it was me, I will remove myself. I will move myself out the way. Me.
But if he grant the mistrial, if he grant one of these mistrials, it happens all over again, and then he can get another judge to come in without even recusing himself.
Not necessarily.
No, that would be double jeopardy.
If you read
that would be double jeopardy.
If you read the Steele's affidavit, he specifically says mistrial with prejudice. So
right,
it's not going to be a mistrial. It's not going to be a retrial.
It will be
if it's a mistrial. It's over with.
Sylvia, I got a question. As far as your observation, what does the work relationship, or we'll say the office morale for the state?
Yeah, so we say that, yeah. So it's different mistrials, mistrial where you can retry it, and the mistrial with prejudice, which means it can never be brought again. And sometimes that can happen when it's shown that it was some type of misconduct, even by the judiciary, the judge, or the prosecutors, especially the prosecutors. If they did something to cause a mistrial, you don't get another bite at the apple to try again. It's just over with. Too bad. And then all the defendants get to walk.
What does that look like at this point?
Office morale of the state. Key, do me a favor. Use your phone because I hear you in the background. The office morale of the state.
And the reason why I asked is because I was watching a video, and I don't know if you noticed, but it's been some snatching of microphones, like pulling microphones.
We played it on the air.
They snatched the mic.
I'm asking, like, what does the morale look right now? What does it look like? Okay. Based on your observation.
My observation, I see the ladies constantly. Okay, I see Miss Love. I know you're probably watching, but let me tell you, I see her being a tyrant.
Oh, Miss Love watching.
Very bossy with the rest, and she doesn't let the others work on their own, and you know she has to control everything. That's right.
Would you say that the you know how they say the team on has that changed from the beginning of the trial to where we are now?
They have changed. They used to be more cohesive before, but now they have changed. But you remember, they've been changing different people. It's not the same group that started in the beginning back in November when I was there.
That's correct.
You had that lady, Miss Rosenbaum, and then you had Gary. He was there, and then remember, Love was the second chair. It was it was Gary first. When then Gary had to leave because Fonnie wanted him to take a back seat to Love, so he didn't like that, so he left and went to Gwinnett County. And when he left, all the work that he did, he took it with him. So they had to start from scratch. That's why they had to try to buy some time to get. And this is something that I actually got from one of the attorneys, Mr. Axe. He told me I could give his name. He told me that that's what happened, and therefore that's why a lot of things have, like the whole jury selection took a long time because it was buying them some time to get stuff. That's why you can't find this report's not there and all that, because they're creating everything now.
Gotcha.
I mean, we can tell that's what all the breaks are for, all the extra days off, we know he's allowing them real time in trial to get extra time. And if I was defense, I would have told them, hey man, you gotta speed it up, doc.
Hey, y'all, let Keith speak for a minute. Go ahead, Keith.
Hi, Miss Sylvia. Good evening, everybody. Miss Sylvia, I want to say shout out to you. Thank you so much for hosting this every single day, day in, day out. I appreciate you. You're just golden. Your smile, your personality. And I want to say to Kayla, I want to say shout out to you for standing your ground, because I feel like the judge, he tried to really lock her into this case and make her stay in that courtroom the other day when Woody was trying to let her go. And the judge knew exactly what he was doing, but he thought he was smarter. And I'm just so happy that Kayla is lawyered up, first of all, and standing her ground to not be the fault for his chaos. He wants a scapegoat and someone to blame for the mess that he's gotten himself into. And he thinks that every single move he's making, he's outsmarting somebody. But
hey, y'all, just so we're clear, it's two separate motions. And Yvette, the motion you're talking about, that's the one from today. That's not the motion that was read by Miss Sylvia just now. So it's two separate motions. The one you're talking about, Yvette, came from Brian Steele. That's the one that's at the 808 mark. I mean, it's, at this point, it's no big deal. We heard them both, but just for clarity, so people won't be confused. And we're celebrating current. Oh yeah. Everybody good. Those kids up there. Okay. Yeah, so we're just streaming in on using fair use, looking at Miss Sylvia stuff, seeing what's going on. And Kayla is in the building over there. Y'all see her name down there.
He's digging himself deeper and deeper and deeper into a hole. I think tomorrow when we go back to court, he is going to recuse himself because he's gotten way too deep.
You think he will?
I don't think he will. He has no other choice. He is backed up against the wall. Kayla has lawyered up. Brian Steele has lawyered up. So, and then we have the Supreme Court justice now. It's like he has so many people pointing against him at this point. He has no other choice. He would be a fool to not recuse himself. Like, everybody's lawyered up in a situation that he's going against. And Love and Hilton, they know they are not speaking up. They know that they can't say anything to stop what's going on. He's digging himself deep into a hole. I think he will recuse himself. I'll stop there. But what do y'all think?
He's too stubborn to.
I can't. No mind.
I don't think he will.
I think he will.
You do? You do?
Miss Sylvia.
Yeah. I think because he's taking it too far. If it wasn't for the fact that he's got to go on the stand, and Brian wants to put him on the stand, he wants to.
Hey, y'all, anybody in the chat thinks that the judge will voluntarily recuse himself tomorrow, or y'all think he gonna come to court tomorrow like nothing happened, and don't even address the motion first thing, just keep on going business as usual?
to put Love on the stand, and he wants to put Hilton on the stand. And he has total facts to back everything he's saying. Even though he's an elected official and there's really nothing we can do if he don't recruit himself, but he's been
So we got no.
chief judge. And then he just been embarrassed by the Supreme Court, just basically in one day giving
It looks like we got a tie so far about 3 and 3. 3 saying yeah, 3 no.
Real good slap. Like, hey, you dead wrong. So if it wasn't for that and the way he changing how he's the way he's talking to the defense now versus how he used to, it's a whole lot different.
His tone has
coming
changed.
off of that pride and arrogance and realizing he done messed up big time and he don't want to really destroy his total credibility with the court system.
Yeah, I agree.
Wow.
It's like,
So far, I'll say he's shown a conscious indifference to stepping aside. Like he's intentionally not moving. He's intentionally held people in contempt. This not just Brian Steele. He did put other lawyers, he didn't held them in contempt before. There was a lot going on. I think he put a potential juror in jail. So there's so much going on before this. I don't see this being the straw that breaks the camel's back. He want to see how much more weight the camel can carry. So no, we're gonna keep piling on. I don't see him stepping down at all. He might. I even think he's gonna come in tomorrow and just play it off, not even mention it at first, and just go on about the other daily business.
like every move he tries to make with the show cause hearing that he's having next week, he hits a dead end because now Kayla has lawyered up and saying that what you're asking me to do as an attorney is illegal too. You have no proper
Thank you, Michael.
argument or bounds to make me show up in court and get me to testify against something that I was legally in my right course to do so. Every time the judge tries to put forth something defending his actions in his ex parte conversation, he hits a bump in the wall. I don't know how much further he can go in this process. He's digging himself deeper and deeper and deeper into a hole. So we'll see tomorrow, but I think he will have to recuse himself tonight. He's probably having a long conversation with his wife.
Mm-hmm.
He's talking to his damn dog.
We may be all surprised.
Yeah,
Who
right.
looks a lot like Miss Love, I must say.
I'm with the majority, man. I don't think he out of here, man. He gonna deny it tomorrow, and they're gonna have to go over here like Steel Motion said.
He said he's gonna answer Steele tomorrow. He said he's gonna answer him.
Right, and he gonna be like, "No, I denied the recusal," like he didn't already did.
Jack Pierce, shout out to Jack.
You know what? I think the state needs to just give it up because I'm gonna tell you something.
Tell me.
From what I heard, what Woody said, they're gonna have to give it up.
Facts.
Wait a minute, now you can't hint.
But not tomorrow.
Guess.
Wait, Woody said something. See, she knows something.
Giving us a nice little strip tease.
I should have been at the court. Y'all should have been at the court. Hey, Mike.
He said out loud.
Let's go back a little bit. Let's go back. What she said?
Just give it up because I'm gonna tell you something. From what I heard, what Woody said, they're gonna have to give it up.
Wait a minute, now you can't hint towards it. Can we guess?
Giving us a nice little strip tease.
I should have been at the court. Y'all should have been at the court. Hey, Mike.
He said it out loud. Everybody heard it.
I bet he canceled it tomorrow. I got COVID. I got to cancel. I got to recuse.
Did everybody hear?
He can say face that way.
I have no comment. I plead the fifth. I plead the fifth.
Right, because they embarrassed him today. They embarrassed him by showing the videos.
Yes, he's upset. He's very upset.
Yeah, they showed those videos that he didn't want to be shown. That was the whole point. So now I'm sure he's super pissed because it showed him telling everything and the level of fear he had.
Listen. If you listen to the video, in my opinion, if you listen to the videos, he was doing what he's already told us he was doing. He's spending no fault. He said a bunch of stuff that didn't amount to nothing because they didn't arrest nobody.
Right.
And then one of the things they were shooting at him, that was clearly self-defense, but he wasn't finna give him the gun, so he was already on papers.
Right. And he told him from the get-go, he knew they was listening to him and his girlfriend. So that's why he was saying that. And if you listen to his comment, he contradicted himself. He told her, I knew, and then he tell her, no, I didn't know. You know what I'm saying? It's like he was thinking, like he
Even
been
though they're
telling them,
supposed to
I've
hear.
been thinking. He was thinking of the answers, what to say, and he knew the camera was watching him all along, even when they left the room. So, and then, like I was saying about Miss Bumpkin, this is my last comment on her. But she ain't just lawyer up; she lawyered up. And what
With the
I'm
big
hearing about the
dogs.
lawyers,
Big
yeah,
dogs.
right. So
Oh,
what I'm saying is, I believe the defense has set that up, and they got it where it need to be, and they finna get her off of that foolishness because she ain't have no business being put on it. It's down, baby. It's
but
finna go down, and we
aside
got the
from
best person in town to do it, to be in the courtroom. I think you
Jasmine
should put
say
some
this,
video up from yesterday to live because you showed how Doug was expressing it. Nobody got that footage but you. Everybody wanted to see what Thug was saying while Woody was talking. And I mean, I know the sound wasn't that good, but if you could remember what he was saying and how Thug was reacting, and even showing when you showed Shannon when he was reacting, it made it so powerful. I really put in the chat that I wanted that to go viral, baby. And I'm hoping that everybody will go back and watch that video from yesterday and share it and share it and share it because that need to go viral. That was the most important thing that was shown in this whole entire trial. The way Thug was looking and responding while he was on that stand talking about he told his sister, I'm gonna beat her up. I mean, I'm gonna kill him. And it was just how he was like, oh, you doing me a favor right now. So I ain't clicking. No, I ain't gonna show no respect. And he kept looking at you, um, Miss Sylvie. He kept looking at you to give his expressions so that you can capture it. And I really feel like he wants you to put that video out. And that's all I'm
Okay,
saying.
what day was that? Because
That was
Sylvia,
yesterday. That was yesterday.
what number? Because you do yours by number, sis.
God.
I know. I'm sorry.
Let Mister come in here. Mister's gonna say something. Here you go, Mister.
How you doing, Sylvia?
Talking to me?
Yeah, no, I'm talking. He knows who I'm talking to.
You doing all right today?
I'm doing fine. How are you?
I'm all right. I think everybody is getting they're getting away from the biggest issue that's going on. As a Fulton County resident and anybody else that is a Fulton County resident, we are we're paying a heavy price financially with taxes for a show that shouldn't be going on. First thing is like Miss Love, she's trying to salvage her career where she's been the worst prosecutor in Southern Georgia and pretty much has gotten ran out of Southern Georgia. And I think maybe Funny gave her another chance at trying to salvage her career by taking on this case. And you can pretty much see she's willing to do any and everything to win.
And she fumbled the bag as a judge when she was a judge. So she really looked bad.
Absolutely. And the judge also, we're dealing with the judge that is he has an ego problem, and I think that he's planning his exit strategy, which may be, to write a book about this trial or whatnot. And they're both willing to do whatever to win. And the worst part about it is we, the people of Fulton County, are paying for this. Yep. And that shouldn't be the biggest issue. In the beginning of this trial, they're saying that YSL was the reason why crime is up, why they were responsible for 80% of the murders or whatever. But anybody that lives in Fulton County that is within the inner city of Atlanta know that is automatically not true. The bigger issue we have, and I have, is
if you
as
find
of the
out something,
last
come
few
back.
years, no high sexual predator profile cases have been prosecuted or taken to trial. Those are the bigger issues that I worry about in this community. Like, you got sexual predator cases that been on the books. And Sylvia, I think I sent it to you one time. It was like,
Yeah, you sent me the list. Yeah.
It's a bunch of sexual predator cases that are on the books in Fulton County that haven't even been touched. And that's the bigger issue. So we dealing with, I think we all can see we dealing with a prosecutor willing to do any and everything. And how I see it is that if it comes down to this due cause hearing, I think Ms. Hilton is at a point to where she don't want to be a part of the spectacle, and I think she may be the one that flip up on the state. I don't think she's willing to pay the expense of her own career like Love is or the judge is. I think if she have to get up there, I think she gonna tell the truth. I honestly do, because her body language and posture isn't. She's just like, man, I'm over this. I'm over it, but I'm gonna still do my job. But I'm gonna do my job as genuine as I can. That's from my perspective every day of being in the courtroom and seeing what's going on. And it's just sad how Brian Steele can go in as an attorney, catch the judge and the prosecutor doing something that's unconstitutional, and go to jail because he caught them doing something unconstitutional. And anybody that's on here that's a civilian, that should be scary to know that you can wake up one morning and absolutely do nothing, abide by the constitutional law, and end up in jail. Everybody should be very fearful of that. Sylvia, just because of other people wanting to, project their own personal egos or whatever their careers, because that's all this is about. This is love. She's trying to revive her career. The judge is, basically, and what a lot. I don't know if anybody know, but he was an appointed judge. He wasn't an elected official to be chief judge. He was appointed. People of Fulton County didn't vote him in.
It was just his turn.
He was appointed, and I think the next election he will not. And we just missed it. Whereas
he just got elected,
we could have someone oppose, and we missed it by a couple of months. But one thing I can guarantee everybody on this chat, he will have an opposing judge, and he will not be in that seat in the next 4 years. I can guarantee you that, and that's to everybody on this chat. Ms. Love, she will, after this, her career is over. We the people of Fulton County, this is not what we paying for. We're not paying for this. And I speak for a lot of people in this county, and we've already sat down and figured it out. Judge Glanville will no longer hold that seat next election. I can guarantee you that.
Okay, sir.
All right.
Thank you.
If you got any questions you want to ask me, I know you want to ask me any questions, but I may give you one good one. Go ahead.
People don't know who you are, so I can't ask the question. I'll leave it alone.
All right. Well, I'm gonna stay on the chat. You can mute me, and if I see something or I want to chime in on something, I'll hit the unmute button.
Y'all, he's big time, y'all. This man.
Well, I have a question.
All right, I'll answer one. Go ahead.
All right. Well, it's back to Miss Love, because like you were saying about Hilton. Hilton is a baby, so her career is growing, and this is going to affect her more than anybody. But Miss Love, being that she was a judge already, bossy spirit she doing, I feel like she bullied Hilton, and when she realized the bag was fumbled, she's no longer touching it. So what do you think? How do you think that's really playing out between them two, if you're wanting to answer that?
You mean as far as her questioning like the last couple of weeks why she haven't said anything?
That just the whole thing with all of their key witness, with Tick, with this one, is like she's constantly pushing her to do everything, that little bossy spirit she got going on. But now this last couple of weeks is really, she done shut up, moved her hands off it, and left Hilton out there to be like, by herself.
Well,
I got a quick question also.
Go ahead.
Just to everybody, and I think I'm kind of like a little different, or thinking a little different about the case. I actually think the prosecutors are doing a good job from my standpoint. So you guys think that they're all lying when they were in an interrogation room way before this YSL case about all this stuff?
Well, let me respond to that. I don't think anybody was lying previously, but you got to think about the
I do.
previous DAs have had this case, and it was so many contradictions. He knew that it couldn't be prosecuted. That's the first thing. The second DA that was actually assigned to this YSL case with Funny, once he got all the information or what was going on and what he would be prosecuted, he recused himself. So all of the smarter DAs knew that this was a case that was gonna have it challenges to be prosecuted. And I'm quite sure if you've been watching since day one, like a lot of these other
Yeah, I've been
people,
watching day one.
I don't see, and I'm speaking from a very partial position. I don't see where they have presented anything at
So
all.
right. So
Me
in terms
neither.
of their relationship, you think Young Thug, like you honestly think Young Thug and Nut were good friends at the time that Nut died?
How you gonna know that?
When Nut died, I can't speak on that. That's something that
Like nothing Young Thugger know.
I mean, just I'm not saying you giving like factual information, just from what has been
not
presented.
everything I give you, I'm gonna give you factual information. This
Yeah.
not I'm not gonna give you nothing that's third party.
Well,
I'm
but
gonna
what
give
I'm
you
saying is none of us, I mean, at least I don't know, none of us were there to know like Young Thug or to actually know who Nut is. At least I wasn't. So I'm basing it off all the evidence that they presented when it comes to Woody's interrogation. I mean, even the interrogation from today, he walks into the room. He stands up and shows the guy his phone. So it wasn't like he was being held down, a light in his face, a gun to his head. He's volunteering this.
I really like to have a talk with you, when we can, because you really team love, I see. And there's nothing wrong with that. Everybody got their own opinions.
Information when he's free to walk out. So I don't know
But
why everybody think.
you gotta remember that was that third what do you call it, situation, was when he got shot, when the shooting thing. You get the thing. So it wasn't the first time. The first time they dragged him in there, but the second time he went in there.
Yeah. Exactly. But my thing is, why am I going in there volunteering all this information if it's all false? So my thing is, I think he was being truthful about a lot of stuff that he was saying, thinking this stuff would never come out, and he just happened to be in the midst of all this stuff and it came out.
I don't think everything he said was truthful.
Not everything. I mean, sure. Yeah. I mean, I would agree with that. Not everything.
Because he even said that his purpose was each time he interacted with them was to spin them, because typically they tell him to put his hands behind his back, so I think that was a given. He knew what he was doing. Most street cats, I mean, I hate to say that, my brother done spent police, and we be like looking at him like, that's what you told them? But sometimes it works, sometimes it doesn't. I think that's Woody was well capable and knew what he was doing.
So you got, and I mean, I'm looking at it from like Hilton and Love's standpoint of DK, of Woody, right? They got these confessions that they've made prior that are on tape, and now, of course, they're going to come into court and say, I don't remember, I didn't do it when the world is looking. But what happened when you weren't in cuffs?
the jury, when they go back and listen to the videos, and even as someone that's just watching it, at what point do they honestly believe that when Woody was saying, hey, Thug said, hey, man, leave that alone, let the police handle it? At what point do that become truthful and the weight of that carries over? Because this is something he repeatedly said the first day after the murder.
Boom, mic drop.
No, yeah, I'm not arguing one way or the other. I just think that, I tend to lean on the other side. And I did work in law enforcement at one time, so maybe I'm a little biased towards everything I'm looking at.
It's okay.
But I mean, you got to balance that with also a video of Young Thug saying, you know, all rats deserve to die, or I would have been killed you if I didn't see what you did with your mom. You gotta weigh those things with
Let
the
me ask you
jury.
something.
With the
Let me ask
jury,
you
that's not.
Let me ask you. Can I ask you? I don't mean to cut
Sure.
you off. Those were lyrics, right?
No, that's what he was talking. He was talking into the. I mean, you could say it was promotion, but that's what he was just talking. Those aren't lyrics.
Oh yeah, that's when they was making the video. But they actually said that there was promotion, and not only that, the guys who was testifying to those videos that they got entered through, they said that it was for promotion. Like we can say it's not against the law to say whatever unless you're directing the threat to somebody. We could say whatever we want to say. That's our constitutional right. It's just when you act on it and break the law, then it's a problem.
Yeah.
So you can't. My issue is they picking and choosing certain things and taking it out of context. And some people that are not in the courtroom every day, they pick and choose what they want to hear, whatever side, whether it's on the YSL side, whether it's on the state side. People pick and choose what they want to hear, but you got to think about it. Like you got to get the overall picture of it, and what I'm getting is the overall picture. Like I'm not going to be, if I'm in the courtroom, they speak to me, whether it's the defense or the prosecutors, I speak back. I'm not biased. The only thing I have an issue with is do your job, but don't do your job dirty at the expense of Fulton County. Because what's gonna happen is man, somebody's gonna
So he an
get in
attorney.
that courtroom and it's however the judge and DA feel that day. Get him 20 years for jaywalking. Like
Mm-hmm.
that's pretty much what's happening now. Brian Steele was going to jail because he was defending his client's constitutional right. And that should be scary to anybody that's on this chat. Anybody.
Absolutely.
Well,
It
here's
is.
how I feel. Excuse me. My whole synopsis is this. This is going to be the justice system, and until we, as the people, the same ones that are sitting on this chat line right now, okay, on the Miss Sylvia show, we
And
as
talk that
elected
law.
officials, no matter what state that we are, okay, start doing something about it and potentially protesting about it. It's a grateful thing that Miss Sylvia is the person that she is, and she's bringing us the content. It's very beautiful. I mean, because that's a starting point, all right? And we need to constantly continue to keep supporting her. But each and every last one of our disagreements or agreements
Boy, he
needs
team
to
love. He say
continue
Woody.
to keep going.
He say Woody dirty.
Because this is not going to be the first time that this happened. And it's not going to be the last. And I'm hoping that Miss Sylvia is going to keep going on for the long run, no matter what case it is, because they've been doing this to hip hop itself. It's not to R&B, it's not to gospel, it's only to hip hop because hip hop gets the most money quickly, okay? And it's about young black men, no matter whether they're in gangs, okay? No matter whether they don't care how you grew up, why you're doing what you have done, the things you had to go through. If the Lord put you on the other side of it, they don't care about that. We're seeing it right now. This is something that was potentially 10 years ago. We have not heard anything for me to fathom, I would say 5 years. It's like an expungement. You can get your record expunged, okay, after 3 years, all right? But the United States of America says, until someone does something about RICO and bring it back up, we will continue to keep going with this. Like Woody, like we just gonna act like everything Woody did not say that they wanted to play the video. It was pointless. They should have just started off with the video, okay? But no one, whether it's the Supreme Court or whatever, is making any ruling saying, okay, you're wasting too much time. If me or you, whether it's traffic or criminal, as long as it's not a RICO, get locked up, okay? Guess what? We're in the courtroom in 30 days and they're going to hand us our sentence, not unless we ask for a trial or whatever. And then that's still going to be short. We got to be there on time. If we don't, then guess what? There's a bench warrant, okay? Or your case has already been seen.
All right.
this is pure injustice for them to act this way, but I think they're doing it
All
because of the
right,
media.
wrap it up,
Okay,
sir.
I
Wrap
think
it
they're really
up.
doing it because of the media, and sooner or later,
All right. Well,
okay, they're going to have to start doing some things.
y'all think
I
Kayla
was
gonna come
surprised to
back?
see the appeals court act so quick. Definitely, I thought that was going to be some weeks or whatever, but it also shows you the power of attorneys, the power of backlogs, because if you can get a result that quick from the appeals court, and if you, me, Miss Sylvia, or AJ, or anybody else put something in the appeals court, man, it's going to take probably like 3 to 6 months wait before they even get back to us and let us know they got our case.
Now it's gonna take years.
Yeah.
What can I say something?
Go ahead.
I agree.
What I'm saying is what C was saying about some of the things that Woody is telling the truth about, but it's the obtaining of the information the jury is going to want to know.
Who is saying,
He's
man?
telling a lot, but some of these things he's getting from what someone told him or what he did with other parties. And most of the things that he's telling, it includes too many people where I believe the jury probably believe him, but he's lying because he had to go out from the first interview. Then he said people was in his head telling him things. So when he came back, some of that things was because of what other people said. So yes, he is saying what's on the video, but most of the stuff, like C said, at which point do the jury question how did he obtain this information? How did he know it? Is he telling the truth? Is his sources is really good? Because maybe what he was saying is a lie.
I don't think here's my honest belief. I feel it in my heart that listen, I don't even think that the jury cares. I think, like Miss Sylvia said, these juries been tied out. The jury is just like everyone else that's sitting on this panel right now. Okay, like we said, this is either going to be a hung jury, okay, or it's going to be a dismissed. Okay, I don't really think that they care. The mind works off of yes, we can continue to keep obtaining information, new information. That's fine. Okay.
APD.
What the synopsis is the beginning. Okay?
He said APD. Yvette, did Woody used to work with you at APD? Somebody said.
Okay? And Woody in the beginning said, listen, I told y'all I lied and blah, 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 blah. Okay. And now that they came back and played the daggone videos, it's just confirming to the state, to the witness, jury, especially if it was me. All right, because I looked at it today like, and everything Woody said, regardless whether we say Woody lying, he telling the truth, he faked the truth. Everything that he said yesterday with Hilton for the past 2 weeks, questioning him over dumb stuff,
She said no.
stuff, y'all played. Y'all played with taxpayers' money, and y'all played with the jurors. All right? If I was a juror, and I'm pretty sure not just me, it's going to at least be 2 or 3 jurors, okay, out of 12 that feel like a
We're
lot
finna get him a few more minutes, and we're going to have to let him have it.
of this is frivolous. Period. All right? But Judge Glanville can sit back at the end of this and say, well, please do not take this into consideration, and please, only do what I tell you to do. But they grown people. Judge Glanville really can't really tell them people what to do. He can give them the aspirations, all he want to give them, okay? And he know it. That's why every day, for the past 2 weeks, and Miss Sylvia can mark my words and go back and look at everything. For the past 2 weeks, Judge Glanville has added more stuff to his admirations each and every last week. Almost each and every last day, because he knows what's going on. But he can't stop it.
I think he adds those because, just my personal opinion, he's probably in fear of some of the jurors like going on and seeing what is actually going in the courtroom.
What's like the average time most of y'all be on? Is it mostly morning or noon, or when y'all get off of work around this time?
And because he keep emphasizing on those every day. Don't listen to third party and don't let it influence you in any kind of way. So I think he's more in fear of that. And I think he Well, I know because I was actually in the courtroom. When Brian Steele brought up that about the ex parte meeting, his anger was he was angered because I think he saw his career just flash before his eyes because he knew he had did something unconstitutional. So he's now, I think he's walking back a lot of the stuff and he's trying to salvage what little career he does have left. He's went into, even when he made that decision on Brian when he said
Oh, okay. Thank you for clarifying. I don't know why I thought it was Atlanta. Thank you for clarifying that.
in the jail, I'm sure he went and made a call and they told him, look, you done messed up, but you can still do what you want to do. And
Yvette, you want to come up and talk or nah?
at that point, he was like, well, I'm still sending you to 20 days in jail because you got to think like they're higher. And I'm going to say this. Not only do I know that the Georgia Supreme Court is watching this trial, I know the United States of America Supreme Court is watching this trial, and he watched his career go down the drain by a bad decision that he made.
So I have a question too, if I may, Sylvia. So during the ex parte meeting, right, Steele came up, did his thing, and said during the meeting that Woody admitted to killing Nut, right?
Mm-hmm.
Woody now has blanket immunity. Whatever he says on a stand cannot be used against him.
That's technically not true. He don't have blanket immunity. That's the confusing part that the judge told Woody that he had blanket immunity. That's simply not true.
Killing Nut, right?
Mm-hmm.
Woody now has blanket immunity. Whatever he says on a stand cannot be used against him. You good. Say whatever you want to say. I know it's some question about feds and things of that sort.
All right, thank
And
you.
what jurisdiction? Hold on. What jurisdiction now?
Let me finish this statement real
quick.
Go ahead. And y'all can answer the question however y'all want to answer. Told him you got blanket immunity. You good to go. Whatever you say is good. If he's the one that actually did it, why would he get on a stand several times, which I thought Hilton did a great job of, and say, no, I did not. I was at my girlfriend's house. I did not kill Nut. So either still got false information or still is throwing out inaccurate information in court, or Woody's got to be the most incompetent person ever. Because if I think that a reasonable person did it, they would say, oh, I can get off with that? Yeah, sure. I did it. I'm out of here. No problem. But why would he then say I didn't do it?
Couple different components. Woody,
I might do the short. I never did one before. I think that'll be a good idea. Thank you, Coco.
Doesn't have federal immunity, and what Steele said was that Woody said that if y'all put me on the stand, I'm going to say I killed Nut, and the prosecutor said, if you say that, we're gonna lock you up right now.
Right.
But where's that statement at? I've never heard that before.
It's in the paperwork.
It's in the paperwork.
It's in the paperwork from the judge's chambers. I didn't think that's been released. That might be speculation.
No.
Maybe I missed it. Where's it on the paperwork?
I read it and I read it on my my live.
Oh yeah, see he ain't
and that's from the court reporter's writings inside of,
because he said he told them that he didn't want to testify anymore, and that he was going to get up there and say that he killed Nut. That's the first thing. Let me answer some more questions for you too. Woody has been indicted twice for the murder of Donovan Thomas. He's been indicted twice, and the charges have been dropped twice.
Did you know that, Mike?
Shannon.
Yeah, yep. I knew that.
Shannon and Yak has been indicted for it, and the charges were dropped. But Woody was picked up and initially indicted twice. He was the first person to be picked up. These are the things they're not telling y'all. And that's where it kind of get a little frustrating to me, because I'm like, they not giving the people the whole story. Woody has been indicted twice on the murder. But
so it sounds like to me that they don't even know who killed them. And that's why they're doing what they're doing.
There you go.
That's why, because that just sums it all up right there. If you indicting a person 2 times and then you're going to indict 2 other people, and then the charges drop. Ain't this much immunity that's going on in the world? I'm sorry. You know what? Let me back that up, because this is the United States of America. I was gonna say something else, but this is Miss Sylvia's channel. But
Your phone is messing up. Your phone is messing up. His phone is messing up. Is it messing up for y'all too?
Yes.
Yeah.
Yeah, that
So
means
Miss
that's a
Sylvia,
wrap.
quick question.
That's
I
a wrap.
really didn't get
All
a
right.
clear answer. Everybody was kind of talking. Is it from the court
Weinstein,
reporter?
Weinstein did a motion with it, and he specified it in the motion itself.
Right, because the
But my question
witness,
is, if Weinstein and Still were not in the meeting,
the person who
right,
was in the meeting told him.
how then do they know for a
Oh
fact
my God,
that was said?
her name is on the screen. He haven't been here. Kayla was the one that told them, man.
Weinstein and Still were not in the meeting, right? How then do they know for a fact that was said?
The person that was in the meeting.
The person that was, yeah, go ahead.
Oh my
gave the information.
And then Weinstein is a member of the board. He's a
wait, no,
what is it?
They can put together what he said,
officer.
but can't say you told
If
him.
he put it in a motion, he has to stand by it as fact.
Okay,
And he wouldn't put something in there that he did not know that he know that he know.
But you remember one second, Saucy. Remember, the judge never denied what was said there. He was upset about who told. Why did they tell?
He never
remember
said
that?
it
That's
wasn't
what
true.
the judge was upset about.
Yeah.
Yes, ma'am. Yeah, I remember that. But I guess I think my argument is just not. Maybe I'm not just explaining it right. But like, let's say Love come out and say something tomorrow and say, no, that's false. It sounds like most people on the channel wouldn't believe it, right? But she's a bar member. She has a card like everybody else. My thing is,
right?
I don't know. I'm kind of waiting to see what happens on that date to see exactly what the court reporter wrote.
I think Love credibility is shot because she's lied in front of the judge on record, and Keith Adams had this.
Oh, y'all, what y'all think? This is a lie. This is a lie that'll wear anybody out. Anybody out. Anybody had anything they wanted to say? And for those who want to keep watching it, Infamous Sylvia is the channel. But I think most of the channel here is about ready to fall asleep. Oh man. Wait, what is going on with this connection? I don't know. It's doing something weird again. Yeah, somebody want to come up? Yeah, we got the gist of what was going on. Kayla not gonna come up and say anything. Kayla probably gone anyway. Yeah. Oh yeah, thank y'all for sure, and for the new subscribers, and the ones that haven't already. On your way out, hit the button. Somebody say, Michael, you come up. Yeah. The Georgia Supreme Court has the judge in a bad place. Yeah, they really stripped him of his power. Make sure that you mention her such you can give her credibility for the video shown. Oh yeah, exactly. I think Infamous Sylvia is her channel. And I use the video under fair use. So thank you, Miss Infamous Sylvia. I might reach out to her one of these good old days so we can talk about it. We can talk that law. Y'all think she gonna have me up? And I understand I'm not everybody's cup of tea. Somebody say, Michael, what's that? Liquor? Yeah. But all right, I'm gonna try to get back, I guess, tomorrow. Yeah, thank you. Yeah. So we were on for like 10 hours today total. Let me see. I didn't see it, but I'll go find it. Yeah, I definitely support. Uh, definitely other YouTubers, no problem. So I'm trying to find the right time to do it because supposedly there's no court tomorrow per se for the jury. From my understanding, it's just the judge and the lawyers working out issues. But it seems like that's something we don't want to miss because tomorrow anything can happen. I mean, the judge got these motions from Kayla Bumpus and then from Brian Steele today. So, I mean, I'm inclined to jump on. He said 10 o'clock tomorrow, 10 o'clock Eastern. So it's 11 o'clock Central. Thank you. Thank all y'all. Bourbon with the orange peel. Yeah, so what I might do is just get on probably earlier when court starts, see how it is. But it seemed like it was actually good. We had a morning stream, and then we had one in the evening that I wasn't even prepared for. It was nobody thought this was gonna happen, but Brian Steele walked up to the judge at the end of trial. And he said, "Hey, Judge, I got some for you." He said, "I'm giving you a courtesy copy." And I was like, make sure we see the early morning drama because it's going to go down. He said, "I got a courtesy copy for you." Now, matter of fact, let me see something right quick while I'm here.
Welcome. In front of me, I have.
Let me see. YSL. He wasn't giving the judge no. He wasn't giving the judge no courtesy copy. He wasn't. He was letting the judge know, like, "Hey, judge, you tried to have me arrested, so I'm going to deliver this motion personally." Let me see if I can find it. Let me see if I can find that little piece. That's probably, somebody said that's why Brian Steele was kind of quiet all day today, because he had this he had it planned out what he was going to do. And obviously he couldn't get too close to the judge because of the partition, so he couldn't jump over it like that man did in Las Vegas. But he did go as close as he could to give it to him. Let me see. Present. Stop screen. Present. Share.
All right. Okay. Anything else I need to take up with you all before we recess?
Nothing to say.
This is the 5 minutes to serve.
Look, Miss Love already getting uncomfortable when he walks. She started like, she started playing with him, and here he go.
This is the 5 minutes to serve.
Oh, he passing them out.
State and record.
Y'all see, he gave a copy to the state, but he didn't give it to Miss Love. He gave it to her assistants in the back.
State and record. But it's being filed as well. This is not a file copy. Just a courtesy copy.
A courtesy copy. That wasn't no courtesy copy. That was a B, I'm getting you back copy. That's a B, I'm getting you back copy. Look at the judge reading it. The judge did not like that. Look at her. Look at his love. Look. Miss Hilton, shame. Hilton, shame. She knows. Brown, sit down, Brown. You can't handle this. You too light. Oh, so you too light in that. You need some heavy hitters. Miss Love ready to get her purse. Look, she get your purse, Love. It's time to go. Oh. Look at Miss Hilton. Look. They know it's the end. Wow. Somebody said rewind. All right, I'll go. Look. Hilton, you shouldn't have did it.
Okay, we'll take it up tomorrow, Mr. Steele, okay? It'll be e-filed tomorrow, so we'll take it up then. So, all right, anything further?
Look at it. Anything further? Trying to play it off.
All right, we'll see you tomorrow morning for Thursday. For anticipated 10 o'clock start time, we can cover.
So tomorrow we got the time right here.
9:30 for anticipated 10 o'clock start time, and we can cover.
Oh no, it was fine. Yeah.
Listen to whatever we've gotten through so far.
See, when y'all heard what he said, that he said they can listen to whatever we got to so far. It's almost sounded like the jury's going to be there. Let me go back. Y'all can help me understand that. He said they can listen to what we have so far.
Tomorrow, and tell them they can come in on Thursday.
Okay, he said, okay, hold on, let me go back. It sounded like he said the jury could come Thursday. Let's see.
All right, counsel, is anything further? What I think I'm going to do is, unless you have some strong objection to the contract, I'm going to excuse our jurors for tomorrow and tell them they can come in on Thursday.
And then he gonna say something right after this.
Thursday for 9:30 for anticipated 10 o'clock start time, and we can cover what they can listen to whatever we've gotten through so far.
Oh, okay, got you.
Objection from the state, Your Honor.
Anything from the defendants?
All right, yeah, I misheard it. Y'all right.
All right. Okay.
Oh yeah, I was gonna finish that. They turned off the
before we
we're gonna see this one more time.
Recess.
Nothing to say.
Look how Miss Love is. Look how they look.
State and the court. But it's being filed as well. This is not a file copy. Just a courtesy copy.
Look at her. She wanted it right away. Look. Oh man, this is comical. Brown, sit down. The judge trying to act like he has a good poker face. Talking about we could take it up tomorrow like he's not phased. But you see he sat there and turned through every page. You ain't that phased, you just look at the title. Somebody saying nobody had COVID, Isaiah. They just trying to hide them signals they was being given. The clerk like, hey, just clear my name because I didn't leak nothing. The clerk, y'all are funny. The clerk like, hey, I still gonna have my license. I'm gonna be typing for another judge up in here. I'm not going to jail with y'all. That's where she gonna draw the line. With her chucks on.
Okay, we'll take it up tomorrow, Mr. Steele, okay? It'll be e-filed tomorrow, so we'll take it up then. So, all right, anything further? All right, we'll see you tomorrow morning in fact, hold on.
I'm gonna make sure I jump on tomorrow so we can catch some of this.
We'll see y'all tomorrow morning for 9:30, okay? All right, see you then. All right.
Yeah. Wow. This is insanity. Insanity at its finest, y'all. Still passed it out before they went home for the day. They probably had some smiles on their faces until he put that stack of papers in their hand. Oh yeah, I'll put up just the end because I cover most of it. I'll just do the end real quick. It was just the affidavit, and then we can all get out of here. I'm gonna do it right quick. And for those that gotta run, thank y'all for stopping by. Let me see real quick. Share the screen, share. Boom, boom. So this is pretty much the affidavit of Brian Steele and Keith Adams. So they wearing a mask. Supposedly someone got COVID today, Kevin. Oh, thank you, Tia. Tia is on it. She sent me this motion earlier today as well when it first hit. When I was finna sit down and eat at the dinner table. I had took my tie off and everything. When she sent that motion, when I tell you I got that tie so quick and whoop, tie, hey, I'm back. My food done got cold. They thought everything was sweet. Yeah, they thought it was sweet. They didn't know who they was messing with. They did that got your ass pound again. Let's go through a few of these for those who can say. And I'll read Bumpers one tomorrow. Thank you, Tia, again for sending that to me. I'll read that one tomorrow. And I'm gonna finish this last page up for this one. And this is the one Brian Steele filed today. Brian Steele and Keith Adams. This is personal. I'll be waiting on you to go live. Thank you, Tuki. Thank you, Coco. I'll definitely read that one tomorrow. But let's do this one real quick, just real quick. My mouth's so dry and talking all day, I don't even know if I can read it. So basically, they are saying they're over 18. So they make this joint affidavit based on personal knowledge. They said, didn't nobody tell us this? This ain't something we heard. This is something we know. Still waters run deep. Come on. Thank you, Tia. They said, we know this for a fact. We are counsel for Jeffrey Williams. June 10th, they both learned that an event of facts, a secret meeting, occurred outside the presence of Young Thug and outside of the counsel for Young Thug, which is Brian Steele and Keith Adams, in a star chamber-like environment. They said a secret environment. So Monday, June 10th, we all know this. They asked for the transcript of whatever conversations were memorialized. And Brian Steele and Keith Adams requested the actual recording of anything discussed at this improper in-chambers meeting on said date, June 10th, 2024. The court then obstructed Mr. Williams and his attorneys from having an exact image of what was said. This obstruction alone shows that the court is biased, as there is absolutely no privilege in communications in this court's chambers, as the court argued on June 10th. And there is certainly no attorney-client privilege under any stretch of the imagination, as the court asserted. So real quick, for it to be attorney-client privilege, it has to be between you and your attorney. But when there's 15 other people in the room, right, there's no privilege because it's public information. So you can't say it was a secret between me and my client or attorney Bumpus and Kenneth Copeland, aka Woody, when you have the judge in there, the court reporter in there, all of the security bailiffs that supposedly turn off their body cameras. You had the DA's office, their team in there. So it was way too many people in there for even it to be remotely considered attorney-client privilege. So the judge was absolutely wrong. We're going to clear it up. She said, clear it up, clear it up, clear it up. And I ain't even 100%. I've been up all morning. But I'm going to try to give y'all a little bit of it. All right, let's go back. Let's go back. Let's go back. So no attorney-client privilege. So we got that. This obstructionist conduct by this court shows bias, and that this court intrinsically intertwined in the facts of this case and has prevented Mr. Williams from due process, fair trial, effective assistance of counsel, right to know every material and critical happenings in his case. Ooh, this is a lot of reading, y'all. Further, this court, by its own words, used the record when speaking in open court. So what they're saying is they have records. The court reporter typed her notes, and she has a recorder that she used. So we know for a fact that there's a record of some notes that was typed by the court reporter of the secret meeting, and we know that they have a tape recorder that's in there as well. So we know for a fact the judge admitted this on the stand already, so they can't try to destroy the tape in the transcript unless they're really trying to go to jail. Okay. So when speaking in open court with Brian Steele and Keith Adams, as well as the court's silence, as well as lawyers' love statements in open court, clearly demonstrate that the facts below are true and accurate. So basically what they're saying is when Brian Steele spoke in open court, nobody said anything. The court didn't correct them. Lawyer Love, DA Love, she was silent. She didn't say, hey, that's not true. That's not true. So it must be true. The court also, or has also silenced witnesses by improperly issuing a show cause order. They issued a show cause order for the DA's office, for the court reporter, the police officers. But we know who that show cause order was really for. He put all those other people in there for show, but he really want Caleb Bumpus and Woody in his office or at the court hearing for the show cause hearing, because he knows it was one of them. He know it was one of them. He know for a fact. And obviously, Miss Bumpus, she filed her own motion. She confirmed it. The court has also silenced. Oh, did I already read that? So much. All these words are starting to run together this late in the day. So the court, they silenced the witness. They issued a show cause order, making all witnesses in fear of going to jail if the truth is told about this improper violation of Young Thug's constitutional right to be present at every critical stage of this trial, his trial, fair tribunal, effective assistance of counsel, due process under the law. Goddamn, still the right to make a record in the case. So what they're saying is the witnesses, the court is attempting to silence the witnesses because he said if y'all talk, y'all going to jail. So I don't I'm not surprised that Caleb Bumpers didn't want to talk today on Miss Sylvia's channel because he's trying to put him in jail. He's telling them, I'm having a hearing on the 25th and I'm trying to put you in jail. That's what he's saying. Let's keep going. This court is biased. He telling the judge in your face, I'm not scared. What you gonna do? Put me in the back room again so the Supreme Court can sit you down again and tell you I'm the boss, not you, Glanville. The Supreme Court can say I'm the boss. This court is biased and must be recused. They also say that further, the cross-examination of Mr. Copeland Woody will include facts that occurred at this secret Star Chamber meeting, which puts the credibility of Lawyer Love, Lawyer Hilton, this court in issue. And this court should never, that's bad right there. This court should never, we don't trust you, bees. This court should never be the person who is in charge of the jury when the court's conduct is being questioned based upon the courts and lawyers for the state of Georgia's actions. So he's saying we don't trust y'all to even monitor the jury. Y'all are so corrupt. We don't trust none of y'all. That's bad when a lawyer had to put that in writing about his own home court, the chief judge. And then what they're saying here is, since they had a secret meeting in the back room, the prosecution has access to materials that the defense attorneys don't have access to. So when it's time to question Woody as a defense attorney, we need that transcript. We need that secret recording so we can impeach Kenneth Copeland. We can say, Kenneth Copeland, isn't it true you said in the back room that you killed Nut? You are the one that killed Nut? Yeah, I said that. So it's safe to say you killed Nut and not Jeffrey Williams and not the other co-defendants. But the judge is refusing to hand over the transcript. So he's compiling wrong on top of wrong on top of wrong on top of wrong because he do not want to give up that transcript, because obviously the transcript is going to show what we already know. And it's Miss Hilton pressuring the witness Woody. It's the judge pressuring the witness Woody. It's the police officers in there, having him in a corner. He's in custody. So he feels like he has no choice but to do what they're telling him to do. Or they told him he will be in prison indefinitely for more than 2 years. Okay, at the last one, Young Thug has been put into a trick box. Not a trick box. Y'all see that? A trick box. It's some tricking going on, but I don't think it's Young Thug. Somebody say check the judge and DA Love. Mr. Williams has been put into a trick box by the misconduct of Lawyer Love, Lawyer Hilton, and this corrupt, dishonorable court. This court must be recused. A mistrial declared barred by double jeopardy based upon prosecutorial misconduct and judicial misconduct. That's what I was talking about earlier. You don't get to cause a mistrial as the prosecutors and then say, I want to redo. Can I start over again? I promise I won't do it again in the next trial. No. If you cause a mistrial and it was because of misconduct, you don't get a chance to start over. There's no do-overs. So now you can go up to Donovan Thomas family and tell them, even though I promised y'all justice, even though I don't even know if it'll be justice because it don't even seem like Young Thug had anything to do with that. I promised y'all this, I promised y'all that. Fonnie Willis, I promised you a conviction. This is DA Love talking. I can't deliver it. Not only I can't deliver it, but more than likely the bar is going to take a good look at my license. So you might be having to let me go from the DA's office. She said her name is Fonnie, not Fanny. She said, don't talk about her behind. She said, when we say Fanny, we are sexualizing her. We talking about her fanny, her rear end. And she don't want to be sexualized. Woman, she said it's disrespectful. Well, whatever the hell her name is, she got a bigger fish to fry now. She got bigger fish to fry than the pronunciation of her name, because they gonna gorilla grip. Funny. They gonna drag her left or right, because now she fighting Brian Steele, and she's fighting Trump's team, because she got that other big case. So her office is getting pushed and pulled at two different directions at the same time. Let's see. Oh, we got a few more. Kenneth Copeland, a witness who had been called, let me go back, who had been called by the state and sworn Friday, invoked his Fifth Amendment and was held in civil contempt. And he stayed in jail all night long. He stayed there all day Friday, Saturday, Sunday. But Monday he came back to court with a different tune. And unbeknownst to Brian Steele and I can't even think of the man's name, Keith Adams, Young Thug, or anyone else, this court met in chambers with Woody, his counsel, Miss Bumpers, Lawyer Love, that's what we're all, Lawyer Love, and or Lawyer Hilton, and at times the court reporter Weaver, as well as the sheriff's deputies and other persons. Wait a minute, and at times the court reporter, so the court reporter probably wasn't even there the whole time. That's gonna be wild if the court reporter come and say I wasn't there. I don't have all the notes. Deputies may have, here we go, number 6. They are corrupt. Corrupt. Deputies may have been instructed to turn off their body cameras. Hold on. Hold on. Now, if they did this, it's going to really be some trouble, because why would you turn off your body cameras? To me, that makes it seem like you wanted this meeting to remain a secret forever. You would have never said anything about this. But that was, that was the judge's fault anyway. Like, when it's like 15 people in the room or more, do you really think somebody not going to run their mouth? I don't care what body cams you turn off. Miss Weaver, that's her man. Thank you to her man. She like us some Woody. Oh man, yeah. Woody can do no wrong in her eyes. Woody didn't want to stand up at the end when the jury walked out. Boy, have a seat. You all right? You've been here all day. We all tired. Let's go. Number 7. There was nothing privileged under law about this improper secret meeting. They met with him, Woody, for a lengthy period of time. It lasted longer than an hour, approximately 2 hours. Judge, are you taking the blue pill with Miss Love? Are you on them honey packs? 2 hours? Come on now. Not at your age, I know. Oh man. And they was, look, it wasn't even one time. They met with the above named people at all of various times. So they in and out. They tag teaming. They was in there swinging. They in there swinging. Say it ain't so. Say it ain't so. Woody continued to make known his assertion that he would not testify, even in the face of being held in contempt, in order to testify under use immunity. And if anybody wants to, on their own time, they had time, you can Google what's the difference between use immunity and full immunity, use immunity and blanket immunity, use immunity and transactional immunity. And you're going to see that it's a very distinct difference that Woody may have not known about, because if he had known about it, then he probably wouldn't be as forthcoming with his answers on the stand. I'm thinking he's under the impression that he can never be prosecuted for anything he say. And I think the judge even explained it to him wrong. We acting up on the judge that got the law wrong. This court and lawyer for Fulton County District Attorney's office, Fonnie Willis' office, and or Hilton ignored Woody's decision and continued to declare Woody that he would be held in custody until he testifies, or if he persists, he will be held in custody until not only Mr. Williams' current trial resolves, but until all 26 indicted person cases are resolved, whichever is longer. They are in there threatening that man. His back is against the wall. They used Woody. They exactly used Woody. They used him, and he didn't know any better. And they had Ms. Bumpers in there, and she didn't really know no better herself. She didn't know, and she worked with crooked ass Love, so she should have known. Love ain't no damn good. If you work with somebody for some years, you know if they on the up and up or not. And I could just tell this ain't Ms. Love first time creeping in the sheets. Let's kill. This court was a participant and was present. They was present during the admonitions and the threats to Mr. Copeland. See, that's witness intimidation. They threatening him to testify. Look, oh yeah, next sentence, this is witness intimidation, coercion. And the court has become a member. The court has become a member. Did I say that again? The court has become a member of the prosecution team. The court has took off the referee's whistle and put on a jersey with a big P on it. It don't say J no more. It say P. He's a prosecutor. And he's hiding behind a judge's robe. He's a wolf in sheep's clothing. Let's go. Let's go. He has become a member of the prosecution team and assistant. He's in the game. He's playing the game. He's assisting the prosecution to induce a witness, a material witness, to testify. This court, lawyers Hilton and Love are now all witnesses in this crime. Not in this case, in this crime. And will be called by Young Thug and his lawyers and possibly the other lawyers, so the jury can determine the demeanor and credibility of what occurred at this in-chamber meeting. They want to see y'all on the stand to tell y'all that y'all ass ain't no damn good to your face. Please note that the witness list is hereby amended by this joint affidavit to include the court, lawyers Love and Hilton, and all other relevant material persons that have information to share with the jury regarding the conduct, words, and actions of this secret communication. This court provided Mr. Copeland, aka Woody, with a written copy of the statute of crimes. See, not only were they threatening him, they gave him a copy of what of his crimes, a statute of the crimes of perjury, as well as false swearing. Wow, this is no subtle gesture, and one that helped the prosecution team to attain their mission for Mr. Copeland to change his mind and testify. So the court, not the DA office, the court provided Woody with a copy of the crimes of perjury. Wow. So the court is literally helping the prosecution. You're not just calling, calls for the prosecution, balls and strikes, where you're helping them out. He actually moved over to their side and he's actually playing in the game. He's playing in the game now. He's in there jacking up Woody against the corner and telling Woody, look, Woody, look at the statute. Lawyer Love, no good ass Love, made representations to this court, and I'm sure they were lies, in front of Woody and Ms. Bumpers, Woody's counsel, the sheriff's deputies, the court reporters, and others that Jonathan Melnick, counsel for Copeland, his regular lawyer, committed misconduct while he was representing Woody. And Miss Love said Melnick was not representing the interests of Woody. So Ms. Love, while she committed her own wrongdoing, she in the back room saying, "Oh, by the way, Woody, your regular lawyer is no good for you. He's working with the prosecution, so your substitute lawyer, I guess, is better." How she know? She don't know what him and his lawyer talked about. These are, see, I knew she lied before I even read it. These are knowing misrepresentations by Lawyer Love to this court, which Lawyer Love continues to do. She liked to do. Put that in there. She liked the lie. He said, which she continues to do. She liked the lie. They say she a big liar, which she continues to do, which biases this court in favor of the state and against the accused, their lawyers, and other members of our state bar of Georgia. Further, the court permitting Lawyer Love, they are funny, to speak ill of Woody's counsel in front of Woody as to the coercion and witness intimidation. This secret discussion violated Young Thug's constitutional rights pursuant to Article 1, Section 1, Paragraph 7 of the Georgia Constitution to be present at every material stage of his trial. The court and Lawyer Love and or Hilton speaking with Mr. Copeland, aka Woody, a sworn witness about his testimony and whether he would change his mind and testify is clearly a critical stage. So they wasn't talking about the weather. They wasn't talking about their sports team. They wasn't talking about other non-material issues in the back, like a safety concern. They was talking about forcing Woody to testify. Oh, here we go. As asserted in her motion, see, they working together. She filed her motion at 10:40 at night. And she even verified facts below. These facts are adopted into this motion by Brian Steele and Keith Adams. These facts are assertions of Attorney Bumpers as statements of her lawyers. So that's probably was some confusion earlier. Some people were saying that she said, "Hold on, gotta pay a bill." People were thinking that we had Bumpers motion, but we did not. So maybe the lead attorney, shout out to the lead attorney in AB, maybe they were reading this portion, and that's probably what the issue was. But we're gonna read Bumpers motion tomorrow. But here we go. Okay, we're finna get the good tea right here. Okay. On Monday at 8:30, Woody and his lawyer, attorney Kayla Bumpers, were escorted to the court's chambers and conducted a secret ex parte meeting regarding whether Woody would testify. See, Kayla, if I was you, I would have turned around. I was, oh, hell no, I'm not going to be part of this. Those present for this secret meeting were Judge Glanville, Corrupt, Woody, attorney Bumpers, lawyers Love and Hilton, and members of the court security staff and deputies and 2 investigators and the court reporter. See, you got all these people in the room. There ain't no attorney-client privilege. That was a lie that the judge said. Wait. What happened? What happened, Katie? What I missed? No. Oh, you're talking about the, oh, okay. Somebody said specify. They say clear the L. We got to straighten it out. It ain't nothing but a little bit of straightening. All right, well, we got this straight. All right, let's go. It's so many he's, her. I mean, I know it's hard. You got to put names on this stuff because, hell, I'm doing it even reading this. I got to clarify because I'm trying to skip read. Okay, where we at? So Woody announced that he planned again to invoke his Fifth Amendment privilege on the stand. A conversation among the parties ensued regarding Woody's understanding of immunity. How Mr. Copeland thought he may testify if he did not invoke the Fifth and certain facts of the case. Once Mr. Copeland learned that he could be held indefinitely, see, they threatening him indefinitely by the court if he refused to testify, not just 2 years as he initially believed. See, what he said, he was going to sit down for 2 years. He said, I can do 2 years. But when y'all say indefinitely, when y'all say y'all going to hold me forever, essentially, he couldn't, Woody broke. Woody said, okay, I can't do indefinitely. I got a daughter at home. I got a child at home. It's just Father's Day. He Mr. Copeland. Woody decided that he would testify. See, once they threatened him with that, he decided he would testify. I wonder what I want to see the transcript because I want to know, Ms. Bumpers, what were you saying when they were threatening your client, when they had your client back against the wall? Did you tell them like, hey, y'all can't be threatening my client like this. I'm not comfortable with this. And I will be letting his main attorney know, as well as the defense counsel. See, when you start saying stuff like that, the room gonna clear out. What they say, they gonna air it out, they gonna air it out. Mr. Copeland added that his testimony would be a lie. The meeting ended and the parties went to the courtroom. This court never assured that this Brady evidence would be revealed to Young Thug or his counsel, and Brady evidence includes the fact that the meeting occurred. Yeah, when you have a secret meeting, I mean, Young Thug has a right to that evidence and his lawyers. Instead, this court takes the position that no information about this meeting should have been revealed to Young Thug. They say, Young Thug, you don't need to know about this. This is my secret chambers. This is my courtroom. You don't need to know what happened in there. Trust me, bro. I'll tell you what happened. Nothing happened. But guess what, Glanville? We don't trust you no more. And let me tell you, I was looking at your suspect from the beginning. So he's saying no information should be revealed to Young Thug, his counsel, Brian Steele, and Keith Adams, or anyone outside of this star chamber secret meeting. This showed that the court has become a member of the prosecution in an effort. See, they plotting. They plot to overthrow, to trample, to destroy Young Thug's constitutional rights to a fair trial. He has a right to be present for each stage, each critical stage. That's a critical stage when you're threatening a witness. Now, and if you think nothing's wrong with that, imagine if they did what they did behind closed doors out in the open. We have all these people ganging up against them, saying they're going to keep him in jail indefinitely, printing up the law and showing the law to Woody, saying, look, this is what I can do to you. Perjury, false statements. I can do all of this to you on top of the contempt of court while you're in jail. That's insane. No way they would have did that in the public. This court must be recused. Okay, so we can just skim down. Monday, June 10th. Okay. One of the fines made above known in open court. The court refused, and the fines is just basically Brian Steele, Keith Adams. They made it known in open court. And the court refused to release the transcript. They are getting ready to cross-examine Woody on maybe Thursday. They're getting ready to cross-examine him. And guess what? They still don't have the transcript. They don't have the transcript to prove that whatever Woody said behind closed doors, what if he says something different when they cross-examine him? They need the transcript to be able to impeach him, to say, no, Woody, you did threaten to kill Donovan Thomas behind closed doors. Even if it's not true, you did say that you killed him, not threatened to kill. You did say that you killed him. So, I mean, they need this evidence, but the judges still refuse to release it. Not only did he refuse to release it, he held Brian Steele in contempt of court. Y'all seen Brian Steele take off his jacket. He took off his tie. He took off his watch. Yeah, they still didn't give it to him. He took all that off like he was ready to go to jail. Damn, Woody Brian still was even ready to go to jail. And not only did they send him to jail, but they ordered him to serve the maximum. The maximum. All in an attempt to intimidate Brian Steele, Young Thug, Keith Adams, from understanding and learning about the courts and the prosecution's wrongdoing. So you can't intimidate a man of steel. See, that man stood on business. He stood on integrity. He said, you can lock me up, but I ain't telling you shit. I said I ain't gonna cuss that much tonight. The court has become a material witness because the undersigned counsel, Brian Steele and Keith Adams, has the right for the jury to understand that this court met with Woody and the prosecutors in order to convince Woody to testify against Young Thug. See, the judge is out of line. You can't meet with a witness and order them to testify against Young Thug. That's insanity. Shout out to Stainless Steel. The improper meeting with the sworn witness concerning willingness or non-willingness to testify in this court, giving the witness a copy of the law of perjury and false statements and discussing facts of this case is what? What that word is? What Brian say? Unforgivable. I'll tell them anyway. It's unforgivable. Brian is so done with this man. Unforgivable. That's insanity. This is not a secret meeting that the court has had with Brian Steele or Keith Adams ever, because the judge tried to hint that, hey, I had some meetings with y'all too. They said, no, not with no witness. On the very few occasions that the lawyers for Young Thug, Brian and Keith had, they announced in open court they were having a meeting. So they revealed it to the prosecutor who were talking to the judge that it needed to speak to the court ex parte secretly. And there was no objection by the prosecution, and the same occurred. And here we go. Never was a witness involved in these rare secret meetings. Brian Steele and Keith Adams demand to question this court and the above lawyers for the district attorney's office as to how many. See, they're saying how many meetings y'all had. We just found out about this one. What if y'all been doing this the whole trial? Somebody said the judge in love is texting back and forth. Y'all see that? Somebody said the judge in love is texting back and forth. What y'all think they talking about? Subpoena them phone records. Hey, you know what? Ashley Merchant gonna get them records. they better cut it out. They say how many, but they said, guess what? Even if it was just one is still too many. This mandates that the court has forfeited its role as an impartial judge and has become a member. He keep putting this in there, so when the judge reading this at home, he gonna get hot as fish grease. He keep telling that the judge, you on the other team's side. I'm gonna watch this. They in there texting. The court, on at least one occasion, has been fed. Who feeding who? Who feeding the judge? They say the court has been fed. What they been fed? Improper information about facts of this case and a witness statement about his refusal to testify. So we already kind of covered that. That's pretty much the same. The court has now placed a lawyer for Mr. Copeland, Ms. Bumpus, and other unknown persons in a position that they need to come before the court on a day certain to give testimony as to who gave the information to affiance concerning this improper June 10th, 2024 Star Chamber meeting with Mr. Copeland, the prosecutors, and the court. The court has become the executive branch instead of the judicial branch, conducting an investigation as a grand jury and a prosecutor. This court has lost all impartiality, credibility, truthfulness, all of that stuff. It's gone. We're gonna put I wish I had a pen. I'll put a big X right there. They lost all that. They lost it. This court has falsely and wrongly accused Attorney Brian Steele of being unprofessional and unprepared in front of the jury. And we know he the biggest one that's unprofessional and definitely unprepared because he take more breaks than a little bit. Neither claim was close to the truth or was accurate. The prosecutor sat silently as Brian Steele was wrongly and falsely accused of improper conduct. The court has violated every neutrality and partiality that it was sworn. Sworn judge, you took an oath. You took an oath. Somebody said previous cases are all now under suspicion. Think about all the appeals about to hit Fulton County on the cases this judge presided over. I agree. And if you had Love in the room and she was a prosecutor, oh, that's grounds for automatic reversal. Even knowing that the court has falsely accused Brian Steele of being unprofessional, unprepared in front of the jury, the court has refused to instruct the jury to disregard the court's improper comments. So Brian said, tell the jury you was wrong. I wasn't unprofessional, unprepared. And the judge refused to do that. He didn't say, hey, ignore those comments that I made. You know, those comments were not supposed to be said in front of y'all, and I withdraw those comments. But the judge said he's not going to say that. This clearly shows that this court is biased against Jeffrey Williams and his counsel in favor of the state. As no fair judge in a right goddamn mind, no fair judge would not correct such a serious misstatement of made in front of the jury. The bias of the court is objectively proven. See, Brian Steele, the court wouldn't have to say a damn thing. I would have corrected the record. The right then and there, no judge, I'm not the one unprepared and unprofessional. It's a few people in here, but it's definitely not me. See, they don't know how to, hey, they don't know how to get it right. You correct it right there. You don't wait. Judge, can you apologize to the jury? No, you ain't got to apologize because I'm corrected. 20. When Copeland took the witness stand on Friday, he refused. Okay, so we kind of pretty much went through that. They should have never had him in there, hemmed up. The court has harmed Young Thug by hiding information from Young Thug, by having secret meetings with the deputy and the media. They saying that the court has harmed Mr. Williams, Young Thug, by hiding this information from Young Thug, by having ex parte communications with the deputy and media. Miss Sylvia, you ain't got no secret information that you ain't sharing with us today, huh? Then Miss Sylvia said she had something, but she wasn't gonna say it. She the media, ain't she? Secret information with the deputy, let me see, and the media, and permitting Woody to assert his Fifth Amendment privilege right in front of the jury. When the Honorable David Botts brought to the court's attention that he had evidence that the prosecution knew, this was an older guy in the back, the older gentleman. The prosecution knew that Mr. Copeland Woody was going to invoke his Fifth Amendment right in front of the jury. The court refused to have a hearing to determine whether the prosecution knew that this witness would invoke his right to remain silent or refuse to testify. And instead, the court had a problem. I always have a problem with the defense with attorney bias. This is backwards. Old folks say ass backwards. This court has shown bias against Mr. Williams, his lawyers, in favor of a home team, the prosecution. And it must be removed and prohibited and barred by double jeopardy. In sum, oh, here we go. In sum, I was wondering if we were going to get here. The court must be recused and or the trial be declared a mistrial based upon the improper judicial and prosecutorial conduct that includes, but it's not limited to. They say we got a list right here, but it ain't the full list because it's not limited to. Lawyers Love and Hilton are now witnesses because they helped Woody change his mind and testify. The court, in secret, assisted the prosecution by convincing Woody to change his mind and testify against Young Thug. The court has obstructed justice by ordering any transcript from June 10th not to be produced to Young Thug, Brian Steele, Keith Adams to use to particularize this affidavit as well as to cross-examine Woody, the court, the lawyers for the state, and others before the jury. Facts of the case were discussed with the court at this impermissible secret meeting, and Brady evidence was not revealed to Brian Steele and Keith Adams by the court and or the lawyers for the state. And Mr. Williams has questions for Woody, this court, lawyers for the state, and others about the improper meeting, how the same occurred, who discussed the fact that the secret meeting would occur, and the substance of the meeting, so the jury can decide whether the court and the state have colluded against Young Thug. I swear that the above is true and accurate. Further, affiant saith not Brian Steele. And he got it notarized. Keith Adams got it notarized. Certificate of service. So they see you got to serve the other side. They serve, all these people got served. See, they sent it to all y'all crooked prosecutors. Demetrius Smith, Adrian Love, Simone Hilton, Dane. I don't want to mess up your last name. Demetrius Smith. Oh, so all four of them. And this was obviously today. Attorney for, yeah. So there we have it. I wonder who kids are. Who has kids? Well, I think those are the people. Normally, when you serve something, you serve all the prosecutors or at least some of them in the DA's office. And that just basically you're telling the court they got a copy. That's not to say that some of these people actually was in the room. I think that's just the team of DAs that's working this case. And Glanville, he's part of the court, so he don't get you don't serve him. Once you file it, the court clerk will put it in the queue for the judge, so the judge will see it. You're not required to serve it to the judge directly. He'll see it through the clerk. Why won't the state just call it mistrial and cut their losses? It's going to be much worse when they're acquitted or found guilty but verdict tossed out. Yeah, and that's the thing. If the state moves for a mistrial right now, then they are barred by double jeopardy because you don't get two bites at the apple. You can't start the trial because once the trial starts, you can't stop the trial and say, "Oh no, I need more time. I got to wait for another witness," because it's double jeopardy. So the case will be over. I mean, I don't know what would be more embarrassing. They calling it quits, so they go down, fighting. I don't know. Is a witness list attached to this? I didn't see a witness list. I'll go back real quick, but I didn't see a witness list nowhere on here. I could be. Let me go back. All right, this is the last page. I'm just scrolling up. No, it's just an affidavit. The order for contempt, that's just an exhibit. Keith Adams. Okay, so they got separate law firms, the Steele law firm and Keith Adams got his own law firm. Okay, I see y'all. They're just working together for now. Yeah, I don't see a list. I'm still going up though. No, there's no witness list on this one. Oh yeah, what media person? I mean, I guess that's the question we can ask Miss Sylvia. I mean, it's probably maybe it was other people in the courtroom. Clarification: Why won't Glanville call it? Guilty verdict won't stand anyway, and he's already in hot water. The way state can retry, right? I don't know. Maybe he feels like maybe he feel like he will be admitting guilt if he quits now. If he calls a mistrial, then the storm, the media storm, and then the state may start launching investigations. So it may seem like he don't want to do that because it's going to be acquiescence to guilt. Like, hey, I'm admitting guilt. I'm calling a mistrial. So maybe he wants to continue as if, hey, I'm not doing nothing wrong. Why would I call a mistrial? So he's going to keep pushing forward. That's only, my opinion, but I can't see no other logical reason that he's pushing forward. Oh, you're talking about the witnesses who was in the room? Is that what you're talking about, Coco? Thank you, Beer Run LLC. Is that what you're asking about? Oh, okay. No, okay. Right. Okay, but it's more witnesses. He said that in a media person. Yeah, it was a media person, but it didn't list the name. It just said that the judge was conspiring with the media. Who the hell on the media was conspiring with the judge? Because I know when let's just be clear because we don't want to get it wrong when we're talking about. This was the sentence right here. The last sentence. The court has harmed Mr. Williams by hiding this information from Mr. Williams, having secret communications with the deputy and media, and permitting Woody to assert his Fifth Amendment right in front of the jury. Well, you know what? That may not be as bad as it sounds. I think the secret communication could be, and I could be wrong, but it could be the fact that Miss Sylvia did say that the media was ordered to not film the arrest of Kenneth Copeland if he pled the Fifth Amendment. They told the media if he pleads the Fifth and he goes to jail, do not film him being arrested. So that might be the secret communication that went to the media because the lawyers didn't know nothing about that. So it may not be, we might be thinking too much into it. But I did remember her saying on one of her videos that they were told, like they already knew that he was going to plead the Fifth and he was going to go to jail. So they were like, when it happens, don't record it. Which is, wild because the prosecutors, they act like they didn't know anything about him pleading the Fifth Amendment. But the media was already alerted on the low in secret that this was a possibility. So that's what I'm thinking that is right there. But yeah, who's Glanville boss? The people. He just ran for re-election, and he won the primary right along with Fonnie Willis. They both won. So they in November. I think she has a Republican challenger, but Fulton County, I thought she's going to lose. And I believe the judge has no Republican challenger, so he's like the presumptive next elected judge, so he gets to retain his seat. So yeah. All right, so I think we pretty much now he acting up. Right? But guess what? Who is over him? So it's not like this question right here, it's almost like asking who is over the president of the United States. You see what I mean? Nobody's over but the people. The people elect the president. But there's systems in place, like the president can be impeached. And obviously, we just seen the president can be charged. So the same thing with Judge Glanville. The Judicial Conduct Board can look into him. The Georgia Supreme Court can look into him. But then also, the federal prosecutors can look to see if there's anything illegal going on. But he don't have a boss per se where they can fire him. If that makes sense, laugh. See, in Georgia, it seems like the governor has power over the DA, but I think she was asking specifically about the judge. I think she's talking about the judge. Yeah. Yeah, I mean the bar, the people that got but some organizations are stronger than others. Some of them can only make recommendations, and some of them actually have teeth that can do something about it. Oh yeah, Georgia Supreme Court. Oh yeah. How long would an emergency appeal take? It seems the DA is planning to waste hours. Well, while they wasting time, they giving Brian Steele time to move his appeal through. So I'm sure tomorrow the judge would deny Young Thug's motion, aka Brian Steele motion, and then once it's denied, then Brian may take it directly to the appellate court. And who knows? I'm telling you, we don't know who Brian meeting with. The Supreme Court might say, hey, we can't do nothing until the motion's filed. And Brian probably said, bet. Brian said, bet. I'm going to write that motion right away. But all right, y'all. Let's see what we can do tomorrow. Thank y'all for sticking in there with me. And I don't know, Georgia, how long are y'all terms? Do y'all know? Is it 4 years? Let me see. Yeah, I think it's 4 years. I'm saying 4 years. 4. So, and that other guy on Sylvia's channel, he was saying that right. But he's going to be reelected because he's unopposed, so he's going to get another 4. The other guy was saying that Glanville's going to be gone in 4 years. People have short memories. In 4 years, they're going to forget all about this. They forgot about Fonnie's stuff in 4 months, and they reelected her, so I wouldn't be too sure about that. But okay. Let me see where we at. Oh, I just see Mookie crazies. I don't know what. Okay. All right, y'all. Let me get out of here. I'll see y'all on tomorrow. Before I go, my disclaimer: no legal advice intended. I'm a lawyer, but I'm not your lawyer. I'm just here to talk that law. All right. See y'all on the next one.